getting a hearing in the court will be cut down even further. It was about 3 to 4 days. We'll cut it down even further. And as a result of this, and 1B, we have said that this staff will be bifurcated into staff which is dedicated exclusively to e-filing. Then second, for staff which is dedicated to physical filing, because we are still permitting physical filing. And third, staff which does our part of the back-end work, namely printing of paper books for judges who require printed paper books. So I think we'll be able to reduce the lead time in the actual date of hearing from the filing of a fresh case even further. Yes, Mr.
With only one suggestion, if Lord should also have a watch behind the back, so that the advocate will also know how much time he has taken. If your Lordship are able to see it there, we need a watch there as well. We can't see behind how much time is taken.
Incidentally, I got I don't know how mobile numbers travel. I get so many WhatsApp messages from people I don't necessarily know. One of the suggestions was, why do so many lawyers have to stand behind the arguing counsel? Because they said, is the arguing counsel not disturbed by so many lawyers standing right behind them? So that's something which, of course, is a matter of a voluntary compliance by the lawyers to let the space be a little open for those who are arguing. And of course, those who are assistant can sit next to the counsel who is arguing.
On the lighter side, apropos Mr. Shah's request, there should be a clock on the back. But for some of us, we need a calendar on the back.
including the learned SG.
Time.
Including the learned SG.
Yes, sir.
We're not
I
going
said, sir, for some of us.
How long we have been arguing?
Yes, Mr. Shah.
One clock would be there. That's all I'm talking about. So may I begin, Manoj? Yesterday I simply stated few things, which was by way of an introduction. I said that
I realized that I didn't say it. I realized why there's a crowd there.
I used to sit for seniors counsel as well. Yesterday, I submitted that after the independence of this country, the NATO states all became free. They became sovereign unto themselves. I also submitted that in the matter of accession to the dominion of India, they all entered into various kinds of agreements, which were, as law declared by this court, is an act of state between the two independent entities, the dominion of India on the one side and the NATO states on the other side. I also submitted that the relationship between these NATO states and the dominion of India was determined by the documents which were executed. In the case of state of Jammu and Kashmir, I also submitted that it was only instrument of accession which was executed between two entities, the dominion of India and the state of Jammu and Kashmir. Making that as the base, that would be the relationship between the dominion of India and this entity. Subsequent to this, when the residuary sovereignty vested in the king, further documents were to be executed relating to this particular state. The Maharaja issues the proclamation of 1948. In that proclamation, he says that we need to have a National Assembly to frame a constitution. This is the genesis. The genesis of framing of the Constitution of Jammu and Kashmir is rooted in the nature of instrument of accession as well as the proclamation of 1948. That's where we arrive the source as to why second constitution for the state. Then the third thing is that after these declarations are made and no further documents are executed, but at the same time, the Constitution of India was being made. So the problem and the issue, the question before them was what is to be done. This is what I said yesterday. And I also submitted that meanwhile, some more developments had taken place, which had an external dimension, which also shaped and influenced the Constituent Assembly of the Union of India. Now, this is the whole scenario which existed before Article 370 was adopted. And I also submitted that the residual power came to be subsumed by Article 370. My Lord's observation was what happened to instrument of accession. But subsequently, when you agree to a constitution, you had acceded to the dominion of India, maybe partly only, may not be fully, you had not integrated, I would say, because you had not executed merger agreement. So the Article 370 subsumed this remaining power, whether we call it sovereign power, residuary power, but it retained the power with itself. And therefore, next question would be the exercise of this power. Whereas the power is there in terms of the instrument of accession, now in Article 370, how it was to be exercised. I will make a digression here. Perhaps at that point of time, it was felt that since we don't have a Maharaja any longer, we don't have any other authority to do it, who would go in almost like a substitute for merger agreement? If complete integration had to take place, how could this be brought about? A mechanism is evolved in 370 that will be entirely for the people of Jammu and Kashmir to integrate with India. Whereas they have done it with accession, they have acceded to Union of India, but to integrate it completely, as I said, shaking hands and embracing, the embracement was left to the people of Jammu and Kashmir, but in accordance with the mechanism and the procedure prescribed by Article 370. What kind of power the Maharaja has retained? Most important was the power to make laws, which I said yesterday. Therefore, Article 370 itself says all of the provisions of the constitutions are excluded. Notwithstanding, all provisions are excluded except Article 1 itself and Article 370. Everything else is excluded. Nothing else applies to the state of Jammu and Kashmir. The first part, as I come to that, I'm just developing this point for lots of consideration. The first part of Article 370 talks of application of laws in list 1, could be list 2, list 3. It talks of application of laws. Now that application of laws, subject to one condition, that since I had donated some power earlier under instrument of accession on 26th of October, like defense, communication, foreign affairs, so there was no further donation required. Therefore, the word consultation was mentioned. Simply consult. Consult does not mean agreeing. You just have to talk to somebody in normal language also. The consultation, you talk to somebody whether he agrees or disagrees, but the dominant person would go in his own way after talking to him. But if for application of it, the word concurrence was required. Now, there's a fundamental difference in consultation and concurrence, where both have to be ad item, both have to agree. When both have to agree, they have to agree in respect of the entry under which the parliament had the power to make laws. But at the same time, you cannot have an extension of a law made by the parliament unless the relevant supporting provisional constitutional entry, main provision, is also made applicable. It is not conceivable that the parliament would have a law A, but there is no supporting provision of the constitution applicable to the state of Jammu and Kashmir, which would support extension of that law to the state.
Yes.
So there were limitations provided in 370 itself with regard to the power of the parliament to make laws for the state of Jammu. First limitation was if you are relating any subject to list 1 or list 3, which is not a subject covered by instrument of accession, then you need concurrence of the government of the state. Concurrence of the government of state would mean, in simple language, concurrence of the people of the state through Council of Ministers. Why was this needed? More on the question of why of Article 370. Why so special provision for state of Jammu and Kashmir? Only for one simple reason, that there was no merger agreement. That's the most important fact in the whole case. And therefore, this autonomy had to be maintained. The state found a way to maintain its constitutional autonomy by restricting the power of the parliament to make law, both in respect of various entries as well as in the substantive provisions.
Yes. Yes.
Even with regard to this, the substantive provision of the Constitution of India, which was to apply, there is further restriction in that. It again has to be done with the concurrence of the government of the state. So there are two places. One, when you want to apply any entry, you need concurrence. When you want to apply any constitutional provision, you need concurrence. Except in respect of what is mentioned in instrument of accession. छोटी की बात ना एक सेकंड I'll just support my point by the very text of Article 370. Notwithstanding anything in this Constitution, the provision of Article 238 shall not apply in relation to the state of Jammu and Kashmir. The power of Parliament to make laws for the said state shall be limited to those matters in the Union list and the concurrent list, which in consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession governing the accession of the state to the dominion of India, as the matters with respect to which the dominion legislature may make laws for that state. Now pause here. It may not, what in simple language it says is that if what is mentioned in instrument of accession, somebody will have to agree that the entry mentioned in instrument of accession corresponds to any of the matters in the union list or concurrent list, and the President of India is to declare that such an entry corresponds to that list, then only the dominion legislature will have the power to make the law. It is not straightway that we agree to the entry and they extend the law. It has to be in consultation, and the President has to almost declare it that it corresponds to the matter specified in the instrument of accession. For that consultation, the government is required. So it means it involves the President of India on the one side, and second is the government of the Jammu and Kashmir. Two are involved in this, government of the state. And then the third constitutional authority is the President, who is to declare that this matter specified corresponds to the subject of instrument of accession. Now, this is only in respect of union list and concurrent list. See the second part. Such other matters in said lists, that means union list and concurrent list, as with the concurrence of the government of the state, the president may by order specify. So here requirement is with the concurrence of the government of state, and the president is to specify in the order that matters other than instrument of accession, whether they can be extended, if so, only after obtaining concurrence of the government of the state. So this is another limitation with regard to the power of the parliament to make law. Why is this? What is the need of this? Parliament has the plenary power. They can make any law under list 1 and apply it throughout India. Despite having acceded to the Union of India, despite being a part of Union of India, the mechanism was different only because it had subsumed the residual authority which the Maharaja had. Now this carves out the space for what we are contending here, why we are before the Lordships. What is the whole case about? We'll take your Lordship's time, the 5 learned judges are hearing this matter. It's only because we believe that we had constitutional autonomy. Under the Constitution of India itself, certain autonomy was available to the state of Jammu and Kashmir, which was taken away on 5th and 6th of August. We're here contending that you cannot take away that autonomy of the state. This is all what the whole case is about. Now, I'm trying to lay down the basis. Where does this autonomy come? This autonomy comes from the instrument of accession is one. And second important thing is Article 370 itself. It doesn't give power to the institution of parliament to make any kind of a law it wishes to make for the state, unless the state government agrees to it. And both by consultation and concurrence. For the purpose of this article, the government of the state means the person for the time being recognized by the President of Maharaja Jammu and Kashmir, acting on the advice. I'll make these submissions later. But what I'm trying to show is this important about D. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications the President may by order specify. Now, this part relates to the constitution itself. The earlier part relates to the lists. There's the power to make the law. But this clause D does not talk of the power to make law under the lists. It talks of the provisional provisions of the Constitution of India as such. Giving power to the president, you apply the provisional constitution side. But in order to maintain the constitutional autonomy, power is also given to the government of the state, that you can request the president, please apply this provision with this modification, with this exception, with this omission. How that is to be done, that is between the two governments. That's between the government of the state and the federal government, the central government. That's between them. That could be a political decision with which the court is not concerned. But constitutionally speaking, there is no power vested in central government or in president to make any law as they wish, as they do it in the case of other states. No consent is required from the other state. No consultation is required from any other state. No concurrence is required of any other state, except of one state, that's state of Jammu and Kashmir. This is the second part which will demonstrate to my notes that how the constitutional autonomy of the state is embedded in Article 370. Then, sir, the two provisos, provided that no such order which relates to matters specified in instrument of the state referred to paragraph so and so shall be accepted in consultation. The same thing as list 1 or list 3rd, you need consultation if they conform to the instrument of accession. Second provision, but provided that no such order which relates to matter other than those referred to in the last preceding proviso shall be issued except with the concurrence of the government. So concurrence is needed for the application of these constitutional provisions. They may as such apply, entirely up to the two governments to agree to that. They may apply with the modifications entirely up to the two governments. They may apply with exceptions entirely up to the two governments. Then, sir, if the concurrence of the government of the state referred to in paragraph 1 of so and so or the second provision so of that clause be given before the Constituent Assembly for the purpose of framing the Constitution, this is again a very important expression used, that while the Constituent Assembly of the state is framing the Constitution and you have given this concurrence, while it is in the process of framing the Constitution, then you will have to place that concurrence before that Constituent Assembly. And with jurisdiction on the Constituent Assembly to agree or disagree with that concurrence. That is what is significant. For such decision as it may take thereon. So in real practical terms, up to 1957, when the state adopted its own constitution, during that period, if at all any concurrence at any state or any consultation at any stage had been done, it was to be placed before the Constituent Assembly of the state. And what's important is that the Constituent Assembly of the state could invalidate that concurrence or that consultation when it says for such decision as may take thereon. Then, sir, is the clause with which we are concerned and which has been used. I'll make this submission later, but I just read it right now. Notwithstanding anything in the foregoing provision of this article, the President may by public note declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications from such as he may specify, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such notification. When we read this clause, this is different from the clauses which are preceding it. And this clause carves out a position for itself when it says, notwithstanding anything in the foregoing provisions of this article, which would be the earlier, the union list, the concurrent list, consultation, or the provisions of the Constitution. Notwithstanding that, the power is given to the President to, this is one of the issues involved in this case. Can we say he has de-operationalized it or has he amended it? The expression used is declare that the article shall cease to be operative or shall be operative only with such acceptance. So the President is given the power to de-operationalize this article. Therefore, a distinction between Article 368, which my lords observed, that had nothing to do with 370. It's a case of de-operationalization of Article 370, subject to the method, the mode, and the requirement of subclause 3 of Article 370. I'll have something more to say on that, but right now, the point which I was making was that the states being free में तो बता रही है
To the Constitution as it applies to the state of Jammu and Kashmir, which is the entry relating to Jammu and Kashmir? Because, the book we have now has the latest, after the 2019, they delete they never give you footnotes. And I was trying to scroll down in what is the original entry when it came in? What did the entry say? The entry in the first schedule to the Constitution relating to Jammu and Kashmir?
In 1950?
Or soon thereafter. How was that paraphrased?
I worked on that also. I have the copy of the original Constitution. It was passed in 1949, 26.
Right.
I have that. What was the situation at that point of time? One. And number two, 1954.
Right.
When that first order came.
The first order.
There were two before. 1950 and 1952, both were superseded by 1954. I'll take a lordship clause by clause that what was contained in that 54 order and as well as what was contained in the original Constitution when it was passed. We need to go back in time. Without that, it's not possible to apply certain standards as we understand in 2023. This is the situation which has its roots in history. And we have to know why, how and why of if we need to recognize and appreciate how and why of Article 370. Why 370 in the first place? Simply it's a historical process, or there were certain compulsions, there were certain constitutional issues involved, because these were between the two states. It was in the nature of an act of state. Why this Article 370? The Lordship needs to understand this Article 370. It is source. And then sort of if I am to say so, sort of a compromise. On the one hand, you said there is no merger, it's not completely integrated. This is one aspect of the matter. The other aspect of the matter is pending as it is. Third aspect is that between the two governments found, okay, you stay with us. You stay with us, but we'll grant you some autonomy. And these are all provisions related to this autonomy. Of course, in terms of 54 constitutional application orders which have been passed, right after 1957 till the last one, 2019, gradually the government of the state has been, if I use that expression, chipping the power of the state legislature. Now, what does it mean when I'm saying so? My legislature in 1950 had the total power of making laws except 3 subjects. So I could make law on any subject, whatever I liked, because that's the power vested in me in 1950. But what happened subsequent to Article 370? The state government is given the power under 370. Look here, you can concur with the Union of India and request them, please apply this entry. So far, good. When you apply that entry, what are you doing and who is doing it? It is the government of the state which is doing it and taking away the power of the legislature of the state to legislate. Otherwise, that power was with me.
But Mr. Shah, all that must have been done with either the consultation or with the concurrence of the state legislature or state government.
Sorry, sir.
No, all this must have been done either in consultation with the state government or in concurrence with the state government.
I'm saying so. I said it resulted in, that's what I'm saying so. 54 constitutional orders which were issued, they were done in concurrence, in consultation with the government. The other flip side of it is that our state legislature continuously lost power to legislate on those subjects, whatever they agreed. I'm not sure the question of wisdom why they agreed or why they didn't. I remember, just suppose what is left in Article 370, you have gradually donated all the power to the Union of India. That aspect is there. But I'm saying in the original intention, what was the original intention of the constitution makers?
So could it not be gathered from
original intention?
Could it not be gathered from sub-article 3?
3.
Yeah. That the constitution makers.
That one?
Yes, sub-article 3 of 370.
3 of the
370. That the constitution, that the framers of the constitution themselves at that stage conceptualized that at one day the provisions of
it's not audible.
That subclause 3 envisages by a process in a given situation that Article 370 would be de-operationalized, to use your phrase.
Yes.
The process is a separate thing. Therefore, to say that 370 has such a permanent character in the Constitution that it can never be amended would be, it's a very, very difficult proposition. Because suppose the state itself had said, that's why to Mr. Sibal also I posed the question.
Yes.
Suppose the state itself says that we want all laws to apply to 370. Then where does 370 go, apart from the chipping issue which has occurred over a period of time? So then we will really come back to the process. Was this the process permissible or not? That would be the question. That's how I look at it.
Yeah. We might have different perceptions of it, but let me share my perception with the lordships. If we don't want Article 370, answer to this question will first depend on, as on today, on 5th of August 2019, was it still temporary, or because of the passage of time, non-availability of the machinery originally contemplated by Article 370, had it become, despite being in Part 21, showing temporary, marginal note showing temporary, it had become permanent. Permanent in the sense because the machinery was not available to remove it. Now, I'll just I'll clear it more.
Testing this proposition, Mr. Shah. Suppose that machinery was to be created, can it be removed? Is your argument that it? See, when you say it has acquired a permanent character, if the machinery, which according to you is the appropriate machinery, and which did not exist for 370 to be available.
Yes.
If that machinery was to be recreated or created or in existence, then 370 could be removed.
Yeah, if that machinery was recreated, that is Constituent Assembly recreated. But which Constituent Assembly? Could you see at subsection 2? Just for I am aware of a lot of observations my lords are making. Please see it as subsection 2. And I would seek your lordship's consideration also on that. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second provisional subclause D of that clause be given before the Constituent Assembly for the purpose of framing the Constitution. So it is identifying which Constituent Assembly they are talking of. And please go back to subclause 3. Notwithstanding anything contained in the foregoing of this article, the President may by public note declare that this article ceases to be operative or shall be operative only with such accepted modifications and from provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Referred to in clause 2. Today, if your lordship were to direct a you form a Constituent Assembly, my humble submission would be
a little different. I am saying, suppose as COs have been issued from time to time, and according to you, by concurrence of the state government or the assembly, were there an assembly, was there a state government which says that all the provisions of the constitution will apply? What would be the scenario?
When our state government says all the provisions of the constitution will apply, they will say so how? Outside 370 or within 370? They have to say so that only through 370.
Right.
That is the route.
That's the route. So
Yeah.
therefore, once they are able to say so under 370, except that 370 remains in form.
Yeah, then it remains a form. It remains a skeleton. Very true.
It's just a shell.
But the root is one. What's important is root is one.
So
If you take away 370, let us take away 370.
even now, in a sense, 370 is not removed in that sense. What has happened is that whatever remained of 370 inside, in their wisdom or lack of it, whichever way you may put it, they've utilized the machinery of 370 to remove whatever was left in 370. That is what has happened.
Kindly appreciate. First of all, who can remove 370 is one question. The lord's observation is that if the government of the state.
The process we have not come to. Process is separate. You have an argument on that, look, this is not the process by which it could have been done. That's it.
Now, if you wanted to do it completely, aren't we going back to the original position? If you want to completely integrate, then we have to get rid of 370. We have to get rid of instrument of accession, which said 3, then we have to execute merger agreement. Because I was an independent state. We go back to the roots.
The roots, Mr. Shah, you rightly said over a passage of time, the merger agreement, the 370, there were developments which took place, historical developments. Then after that, 370 came, it was to govern. Then over a period of time, different matters, as you say, chip by chip, 370 was, the effectiveness of 370 in terms of preserving the right in the states to lay down the law was chipped away over a period of time.
Yes.
Something still remained.
Yes.
That something which still remained, they did it by a process of 370. Whether that process was right or process was wrong is the second limb of the argument, that they could not have done this or they could have done this in this manner. So they have also left now still a 370, but effectively making all laws applicable. So my only query is that doesn't it all come down to one thing, whether the process they followed to do so was flawed?
Leave the process aside for a minute, Lords. I am one of the federating units. I want to be with the Union of India. 370 as it is it in the nature of an obstacle to integrate myself with Union of India? If it is an obstacle, then obviously somebody who thinks that this should not be an obstacle, you must integrate fully like any other state in India. Then he has to first, constitutionally speaking, not politically, he has to get rid of 370 as it is. That's at one.
Again, this goes, Mr. Gopal Subramanian's article argument was, this is a medium of interaction, 370. It's a medium of interaction. Therefore, that's the process you must follow. Now, if we go back historically to say that it has to be abrogated, we must go back to the original, then how does it merge with it? The only thing is that under 370, which is the medium of communication between the center and state, which was established. We established a methodology by which slowly, if you wanted, you could do it. Now, once that is there, it has been done. Historically also, if we see, it has been done over a period of time. Something still remained, as I said, at a cost of repetition. Now, that what remained, they took away by a similar kind of a process as what was being done earlier, but the process is said to be flawed because there was no assembly, there was no elected body in picture. That's the only question I had.
Mr. Shah, just one more thing.
Yes,
If one looks at subclause 2.
2, yes.
Now it says that if there is any agreement with regard to subpara 2 to subclause B to clause 1 or in the second proviso to clause D to clause so and so, then the Constituent Assembly will take a call on it. Correct? Now the Constitution of India, if one looks at Article 1, which is specifically incorporated in the Constitution of India, it says India, that is Bharat, shall be union of states and union territories thereof shall be specified in the first schedule. So the question of merger being complete is absolutely certain. What has been given over here in Article 370 is twofold. One is with regard to the union and the current risks, the right to make laws. They said there could have been even earlier a situation where some articles of the concurrent list or the union list could have fallen in the state list. But in this case, it's case of state of J&K, which is merged with the state of, with the entire country, became part of the Indian Dominion. There's certain rights given to the state legislature to make the laws. That's all.
More rights, more rights.
Yes, more.
In comparison.
Vis-a-vis the list in question, the right to make laws are given to the state legislature.
Yes.
But with one stipulation that the state legislature can, with the concurrence of the state legislature, those laws can, if the concurrence is given, then the central government or the Union of India can also make laws. One. Number two, with regard to the provisions of the Constitution against, with the concurrence of the state in question, gradually the laws can be, all the provisions of the Constitution can be made applicable. That's part 1. Part 3, that is clause 3, deals with abrogation of Article 370 or modification or changes in that. Your case, as far as proviso is concerned, what is the effect of the proviso is something separate. Is our understanding correct?
Yes, yes. Your Lordship is correct. The first part is with regard to union list, the making of laws, very true. The state legislature, my state legislature gets more laws. I will show that exactly the same position. It has more laws, more power as compared to in relation to other states in India. And why in relation to other states of India? As I said earlier, I raised one argument yesterday. I said they merged. When they merged, it is the Constitution of India which gave power to these state legislatures. It was open. I would go to the extent of saying it was open for the Union of India not to give any power. It could have made it totally unitary because they had merged. They had no personality of their own. Their statehood was lost with the merger. But government of the Constituent Assembly of India still agreed that under list 2, they will have the powers. That's the theory of separation of powers now, with different views of this honorable court, whether they are administrative in character, whether they are political in character. We're not going to that question. But with regard to Jammu and Kashmir, it was, as I said, concurrence. On my concurrence, he could do that. So I would give concurrence, they would make law. I would give concurrence, they would make law. This position would continue. Under D, position is the same. I would give concurrence, they would agree for constitutional provisions with or without modification. This power is there. Doesn't it come to your Lordship's mind that when this Article 370 was enacted by the Constituent Assembly, did they proceed on an assumption? This is what I'm importantly saying. Did they proceed on an assumption that this Constituent Assembly of the state of Jammu and Kashmir will recommend to the Union of India to do away with 370 so that it completely integrates? It could not have otherwise because of the instrument of.
I have some reservation on the use of the word completely integrated. Integration has taken place in terms of Article 1.
Integration, I said complete integration.
No, probably what clause 3 says is Articles 370, which is a special provision, can be abrogated, can be modified, and or made applicable with exceptions. That's all. Integration is, as far as Article 1 is concerned, is complete.
Can we divorce it from the context? We're going simpliciter as on today. In 2023, it's easy to say so, sir, with respects that it simply says we can get rid of this Article 370 because it is flexible in terms of one part of clause 3. That's what my lords are saying. But it has a context. I'm more on the context. I can divorce it from the context in order to appreciate and understand it.
Anyway, please continue.
In that context,
You understood.
it cannot be done. Of course, if you divorce it from the context, then of course, just like your lordship is saying that this is temporary. Why are my lords saying it is temporary? Because Part 21 says it styles itself as temporary, transient, and special provisions. Therefore, it is temporary. Why did you put it in Part 21? The marginal note of Article 370 says it is temporary. So therefore, on these two facts, my lord saying this is temporary.
You know, Mr. Shah,
Yes.
one thing which is very clear is that there was no conditional surrender of sovereignty to the dominion of India. The surrender of sovereignty was absolutely complete.
Yes.
And once the sovereignty was unquestionably and fully vested with the dominion of India, then the only restraints which would apply would be on the power of Parliament to enact legislation, so on and so forth. A few restrictions which remained, which were also then, as we have seen, subsequently modified. And in fact, in the Constitution Application Order of 1972, which is CO 93, which we'll find at Volume 3, page 52, the very interesting provision which comes in 1972. In 72, Article 248 was amended in relation to its application to the state of Jammu and Kashmir. And 248 was substituted, which provides for restitutory powers of legislation in respect of all other states. 248 reads with entry 97. Now it says Parliament has exclusive power to make any law with respect to prevention of activities directed towards disclaiming, questioning, or disrupting the sovereignty and territorial integrity of India. Therefore, the order of 1972 makes it now beyond the pale of doubt that sovereignty vested exclusively in India, and therefore no vestige of sovereignty was retained post the instrument of accession.
May I submit to lords of this?
Is it correct that Article 248 now applies, 248 as it is applicable to the state of Jammu and Kashmir immediately before 5th of August 2019, contains an absolutely clear and unequivocal acceptance of the sovereignty of India?
I may respond to my lord's observation. First is the instrument of accession.
3, page 52.
First, when there was instrument of accession, one legal question for my lord's consideration is this: when you accede, this was a general instrument of accession applicable to all the states. When you accede, do you transfer your sovereignty to the union or not? That is answered by this court, fundamental. They said, no, you have not transferred your sovereignty in terms of only instrument of accession. You transfer it only by way of merger agreement. When I concluded,
what is superior? The Constitution of, sorry, what is superior? The Constitution of India?
Of course, it's Constitution of India, but there's no doubt about that.
Constitution of India is the merger agreement. The
not merger agreement, instrument of accession. But with 370 in it. If it was no 370, it was different. My lords,
ultimately,
understand your lordship's mind that one is Constitution of India is there, your instrument accession goes, your sovereignty goes, your everything goes.
Ultimately, it's
But
C7.
it doesn't seem to be like that because this is something which has been there for 69 years. This is how the governments have worked it out. For 69 years, from 1950 to 2009.
Now take a case of an Indian state apart from Jammu and Kashmir.
Yes.
There are restraints in the power of Parliament to enact laws with respect to anything in the state list. Even today, Parliament can't and cannot enact a law on the state list.
No, I will.
Right? Now, the reason I mention it is these restraints on the power of Parliament are equally consistent with sovereignty, where all the other Indian states, in any case, vesting in the dominion of India in India.
No, with
So
respect,
a
no.
restraint, see, the distribution of legislative powers does not affect the fact that sovereignty vests in India. So there are certain areas where the Parliament cannot touch something which relates to a particular state list item. But merely because Parliament is completely disabled from touching a state list item while enacting law, does that detract from the fact that all these states ceded sovereignty to the dominion of India? So what I'm trying to tell you is this, that restraint on the power to enact legislation is implicit in the scheme of the Constitution, the frame of the Constitution, because we do not have a unitary state. But does that detract the fact that Parliament cannot enact a law on a state list item? Does that detract from sovereignty? It does not. It's just a fetter on Parliament. But there are other fetters on Parliament as well. Now you have the goods and services tax, which is another fetter which has been brought in by consent of the states and by Parliament. These are all fetters which don't dilute from sovereignty. Likewise, once Article 1, as Brother Justice Khanna said, says India shall be a union of states, and that includes the state of Jammu and Kashmir. Transfer of sovereignty was complete. Therefore, we can't really read the Article 370 Constitution as somehow a document which retains some element of sovereignty in Jammu and Kashmir.
I'm saying so for a simple reason. The example which my lords gave, that there could be constitutional provisions with regard to other state legislatures that they can do, Parliament can make law, cannot make law with regard to that state legislature. Those limitations can be in the Constitution. But looking to Article 370, when it says concurrence of the government of the state, I say I am claiming it as a right of the state that my concurrence is needed. In the case of other states, where the Parliament may, as a matter of concession, say, look here, I will not do this for you, I will not do that thing for you. That's a matter of concession, not as a matter of right. I am claiming the state right, the state's right not to apply any law of the Parliament unless I don't concur with that law. I'm claiming the right.
I'll tell you, there are provisions in the Constitution which apply to concurrence of the states also. See Article 249. Parliament can enact a law on a matter covered in the state list. And it says that concurrence is required. Just see 249. Notwithstanding anything in the foregoing provisions of this chapter, if the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting, that it is necessary or expedient in national interest that Parliament should make laws with respect to goods and services tax came in recently, or any matter enumerated in the state list specified in the resolution. It shall be lawful for Parliament to make laws for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. That's how Parliament enacted a law for the Urban Land Sealing and Regulation Act. When the ULCRA came into force in 1975, it was preceded by resolutions by all the states because it was a state list item. So even on other states, Parliament has been given the power to enact laws on the state list, but it's subject to the concurrence. Here it's the Council of State, because the Council of States represents the state.
No concurrence required in this council.
It requires a resolution of the Rajya Sabha.
Resolution of the states. Choice is that of the states. Kindly see this. Not for anything under the folio. If the Council of State has declared by resolution supported by not less than 2/3 of the members present and voting that is necessary or expedient in national interest, that Parliament should make law with respect to goods and service tax provided under Article 246A or many matter enumerated in the state list specified in the resolution, it shall be lawful for Parliament to make law for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. Now, it talks of resolution, maybe it also interprets that resolution as a consent of the state, but it has to be in national interest that the Parliament has to make.
Now see 252 for a moment, 252.
252.
If it appears to the legislatures of two or more states to be desirable.
Two or more states to desire that any of the matters with respect to Parliament has no power to make law, but except as provided in Article 242 should be regulated in such states by Parliament by law, and if a resolution to that effect are passed by all the houses of the legislatures of those states, it shall be lawful for Parliament to pass an act for regulating that matter accordingly, and any act so passed shall apply to such state and to any other state by which it is adopted afterwards by resolution passed in the house or where there are two houses by each of the house of the legislature of that state. Any act so passed by Parliament may be amended or repealed by an act of Parliament passed or adopted in like manner, but shall not, as respects any state to which it applies, be amended or repealed.
Therefore, though Parliament ordinarily does not have a law, does not have the constitutional power to pass a law with respect to a state on a matter which pertains to the state list, if two or more states come together and say that, look, we want Parliament to pass a law, here again there's a concurrence required of the state for two or more states. So in that sense, concurrence is not something which is unique to only the relationship with Jammu and Kashmir. There are various shades of concurrence required in the Constitution. It doesn't reflect on the sovereignty of the Union. These are fetters. Now you see 246A, when it came in, as a result of the Goods and Services Tax Amendment. This is a classical case where the government of India or Parliament can do nothing without the concurrence of the states. 246A has completely redefined our notions of sovereignty in that sense, because the states have now been given a vital role in financial matters. Parliament can do nothing unless there is a requisite majority in the Goods and Services Tax Council, the GST Council. So, in that sense, our notions of the parliamentary exclusive competence, the state's competence, that's itself been, Justice Call mentioned that yesterday, it's been an evolving exercise.
Looks like
one thing is very clear, sovereignty was ceded completely to the Union of India.
See, my lords, may I respond to my lord's observations? What my lord finds is that there are provisions in the Constitution
Yes, Misha.
What my lords are observing, which I understand, is that there are provisions in the Constitution where the states can also request the Parliament that you make the law for us, even if that subject of that law may be in the list too, where the state legislature had the exclusive power. But if two or more states decide so by way of a resolution, request the Parliament may make law for that. So it would imply that what is contained in Article 371, where it says that you will apply the law with the concurrence, it's in principle the same as there are other provisions, if I understand your lordship. So there is nothing so sacrosanct about it. I leave it for a minute. What about the constitutional provision for which concurrence is required and the president is to apply with modifications to me after that concurrence? Whether such a provision also exists for the states where they can request the president of India that you apply this constitution to us with these such kind of modifications, or it is not possible for the legislature to say so. So far as making of ordinary laws and so far as making of the constitutional provisions, obviously qualitatively they are different. In our case, concurrence is required also for the constitutional provisions, whether with exceptions and modifications that will also be seen. So ordinary laws, maybe my lord finds the support that there are other provisions, nothing great about it. But nevertheless, that will go against the text of 370 when it says concurrence is required for purpose of list 1 and list 3. Whereas other provisions also provide that in a certain situation, not as a matter of routine, in a certain situation, the states can also require the parliament to make the law. In our case, it is not a matter of routine that they could do so. For every kind of legislation which has been passed at the request of the government of the state, concurrence has been given. So there is no general concurrence.
Yeah, you made the point
all this,
succinctly.
All the 54
should we go on to the next point now? Because we've understood your
perspective. I show that also to allow just one more thing. Also that when these 54 constitutional orders have been passed, what is it that is given to us? And what was that was not given to us? In these 54 constitutional orders, which have been passed with a concurrence, there are some extremely important constitutional orders. Extremely important. Now, for example, take one. Article 3 provides for the alteration of the state's boundary, which has been read. I'm not dealing with that question, but I'm dealing it in a different way. For state of Jammu and Kashmir, you cannot do it. You cannot do it at all in terms of the 54 order. Now, why can't it be done for state of Jammu and Kashmir? The 54 order placed an embargo on it that till the state legislature will recommend for changing the name, for changing the boundary, you cannot do so. Now, this is a modification made in the application of Article 3 to us. Why was this kind of a provision made in Article 3? I cannot lose sight of the situation in which this Article 370A has come into existence. Now, I'll give one more instance, which is extremely important instance. Article 253 deals with the treaties which the government of India may have with foreign countries. But kindly have a look at the proviso to Article 253. I want you also to have a look at it and say why such provisions have existed in its application to us. There are 54 order. 54 order. अरे यार तेरे को पता ही नहीं होता है. 151 में है.
Page 150. Yeah, that's the we just told us volume 1 page PDF page 150.
Volume 1 of the documents compilation. 54 order.
Will it be there in volume 2 also, the constitution? No.
Actually, since we are just midway through the proceedings, if someone can just do this exercise, some of the leading, things which we are going to be constantly referring to, you can just prepare a little one-page index for us. Just not everything, just on one page. Things which now we know everybody is referring to it, so it just becomes very easy for us to.
Several volumes, 6 volumes are there.
Yeah, but ultimately from the 6 volumes, there are about say 20 documents which everybody is referring to. Those, if you can put down on one page with the volume number, it just becomes easy for us. We can keep it on the dais and just flip through it whenever.
Volume 1, page number 54.
What that page?
The constitution of India supplied to Jammu.
Oh, that is at, I think, page 13.
Volume 3.
It's page 13, that's right.
Page 13.
One may be here.
Volume 3, page 60.
So, COR, or you are referring to the constitution as applicable to the
Constitution is applicable.
Has all the learned judges got it or no? Your Lordship has got it?
One is in the GO and the CO and the other is the Constitution. It's the same. 151 मिल गया आपको ना? मिल गया 150.
Should I read it? You also got it?
Yes.
What does it say? Now, 253 deals with international treaties and agreements and conventions, provided that after the commencement of the constitutional application of Jammu Kashmir Order 1954, no decision affecting the disposition of the state of Jammu and Kashmir shall be made by the government of India without the consent of the government of that state. What is being recognized?
Disposition.
What's being recognized here? This is what I'm saying.
What is meant by disposition actually? I just.
Yeah, final disposition, which would mean in 1954, the government of India concurs with the government of Jammu and Kashmir that the final disposition of the state of Jammu and Kashmir has yet to take place.
No, decision.
Read it once again.
Disposition of the state.
Sorry?
What is meant by disposition actually?
Not settlement. Disposition means settlement.
Yes, they agree with it. We can't say. Because in that context, it's all whole story in comparison.
This is in my humble submission. Of course, there are different perceptions of it. This is the recognition of that position which preceded enactment of Article 370.
It doesn't mean that all treaties will not apply to J&K. For instance, suppose the Universal Declaration of Human Rights or the Covenant on Civil and Political Rights, that would apply. Or say the Convention on the Elimination of Discrimination Against Women, that will all apply, right?
We're only on the point of the state's disposition.
The state's disposition.
Now, when we talk of state's disposition, I had already entered into instrument of accession. What does it mean that the state has yet to be disposed and will be done by Government of India only with the consent of the Government of Jammu and Kashmir? Where would it apply? This situation will apply where? This is concurred by both the governments. It's not unilateral action. I would submit this is the recognition of this submission which I made yesterday, that this issue has an external dimension which is recognized in this. It has an internal dimension which is also recognized in this. And both went together with Article 370, clearly carve out a position that state of Jammu and Kashmir has a distinct position pending it is disposition. Final disposition. So what I am submitting is that this state of Jammu and Kashmir, all judgments of this court बच गए कितने हुए? बच गए कितने? टाइम क्या हुआ? हैं? 10 to 1. Yeah. So छोड़ो ना, सामने हम थोड़ी मांग रहे। हाँ नहीं बोल। So, my lords, the premises on which I am building up my case is this: that state of Jammu Kashmir, as all judgments of this court show, has a special and a peculiar position. It is for the first time this court is called upon on a very important issue, whether this can, the way it has been got rid of, whether it could have been done like that. And that does not involve any issue of the procedure involved. It also involves the issue of power. Isn't it something which is basic to all the arguments raised before this court with regard to the power? The power of parliament, the power of president, the power of the government of the state, the power of the governor. The common theme in all these constitutional authorities is the power. And we're examining that issue, we're debating that issue, that something has been done, whether you had the power to do so. This is one. Second, how did you exercise that power? And if the exercise of the power is unconstitutional, then even if you have that power, the action will still have to be invalidated. This seems to be the theme of the whole thing. There ultimately, whether 370 by itself subserves the sovereignty, as I said, it does. But at the same time, the sovereignty is exercised by it from time to time by agreeing to all constitutional orders, passed 54 in number, how those constitutional orders were passed, how they are passed, and what is the effect of those is also an issue. Then also, what is it that we are claiming? We're only claiming constitutional autonomy, which has been taken away from us on 5th of August and 6th of August. Now, how do we get that constitutional autonomy back? Is by demonstrating to the court that what is that I had If I had nothing, then what am I fighting for? It would be an unrealistic litigation, unworkable litigation. It will have no result at the end. Second would be I still had the constitutional autonomy, maybe little, maybe whatever it may be, as Honorable Justice Kof observed, you are talking of a skeleton. Maybe it was a skeleton, but somebody still felt that skeleton was disturbing him, therefore he got rid of it. If it was a skeleton, leave it as it is. The way we were living prior to 4th of August 2019, that the things remain as they are. But then the thought of removing this skeleton, somebody must have thought somewhere that this skeleton must also go. But I am not on the question of this skeleton. I still had the power. Now let's see what was in the Constitution, what was the constitutional application, or in particular 1954. Why? Because it is that order which is amended from time to time. And then what was sought to be protected. Can I say something more, Millers? We are protecting, let's say, the individuals who live in the state of Jammu and Kashmir as permanent residents. Now that is protected under the Constitution as applied to us. I'm just saying that is protected. That was protected earlier also in terms of the notification of 1927. And interestingly, at that point of time, agitation was raised by a community, Milords. Unfortunately, they left us, and we owe a lot to that community because we were taught by that community. Anyway, that apart, they agitated because they were the educated class, and the king at that time would get people from Punjab and other areas. So they said, we need jobs. So they agitated, and that resulted in a notification of 1927 and restricted appointments to the permanent residents. That subsequently there was then notification 1932 that also restricted. Now, when that is protected, now it has protected for several reasons. One could be that, look here, it is meant for the jobs, it is meant for acquisition of the properties. Second also could be that, look here, the state as it is, so the people who live there need to have some rights, some privileges as against others. So they all protection came, that's one. Number two, state itself. Keep the state intact, though we are three regions. We're Ladakh region, Kashmir region, and Jammu region. The Maharaja at that point of time thought that bring all the three regions together, and then we became a state. To protect the whole state. Now what has been done? It has been divided. The people are divided. The part of it is with Pakistan, the part of it is with China. About 2,000 kilometers are with China in Accession. Part of it is with Pakistan, and remaining part is here. We're getting sandwiched between all these forces which are applying in the state of Jammu and Kashmir. Now, by virtue of this, again, the people have been divided now. Now we're reduced to a union territory of only Jammu and Kashmir, and Ladakh has been separated from us. Somewhere, somebody, when they say how to make a law, somebody was asked, a lawyer who was involved in how to make it, he told him, you tell me the political decision, I will tell you the law. Law does not precede political decisions. First, some politics comes in, then the laws come. So looking at the laws as they have been framed, somebody took these decisions to make divisions and further divisions to our state. Now we are claiming a position which it was on 4th of August. We need to be reunited with all the three regions. We need to live as we used to live. And then, of course, over the passage of time, as the government of the state, as I'm not on the wisdom of that, rightly or wrongly, government of the state from time to time did agree, did give its concurrence to the application of various laws from time to time. But nevertheless, there were some fundamental laws to which they have not agreed in the 69 years. Now, for the first time, now this proviso which is added to Article 3, this continues as it is. Now, entry 97, your Lordship just read. Entry 97 is the residual power of the Union Parliament. If any of the subject of legislation does not fall in all those 96 entries, but yet it will be covered by entry 97. It means it is open. If any legislation does not fall either in state list or concurrent list and is made by Parliament, it will fall in entry 97. When it is made applicable to us, it is made applicable to us in a specified manner. What is that specified manner? In 1985, the Parliament enacted Terrorist and Disruptive Activities Act, commonly known as TADA. That did not apply to us. The government at that point of time, I still remember 6th of June, 1985, it recommended to the government of India, please apply this entry 97, but restrict it to the matters which your lordship read just now, questioning the integration of the state, questioning the accession, so on and so forth. Please apply that entry. Accordingly, this entry came to be applied. It would imply that entry 97 as such, with widest possible power under entry 97, does not apply to the state of Jammu and Kashmir. It applies on a specified issue of a subject matter of a legislation. This, for example, I'm indicating another autonomy which I have. I have the autonomy of permanent residence. I had the autonomy of alteration of my state. I had the autonomy of final disposition. I had the autonomy of entry 97. Then there are similar other entries, both in the concurrent list as well as the list one. So I will give you a long list of the entries which apply to us with modifications. And those modifications carve out the constitutional position, the constitutional autonomy which the state enjoyed. Now, see another important thing. The laws of this country obviously give rights to the citizens of this country. That's in terms of the fundamental rights and so on and so forth under the Constitution and under various laws. Now, these laws come into conflict with some of the laws which were applicable in the state of Jammu and Kashmir. In order to protect those laws, what the president did in 1954 order, he incorporated a new article, that is 35A. Incorporated a new article, that is 35A. It is not in the Constitution of India. Obviously, it cannot be in the Constitution of India. It is in the presidential order of 1954. He carved out this Article 35A with the concurrence of the two governments, protecting the employment, the permanent residency, the scholarship. I will indicate that also to your lordships. He protected that as well. Now, this protection, this kind of protection, Article 3, 253, entry 97, all these do indicate I still had constitutional autonomy. It is not that I was completely reduced to a skeleton. Maybe I was on oxygen, but I still was living. I still had that constitutional autonomy in terms of this constitutional position. And I continued with that. Whether this was rightly done or wrongly done, nobody's questioning that wisdom. I mean, that's entirely for the government of the state. And between them, not even the government of the state, but the council of the state. Now see, Parliament is excluded under Article 370. State legislature is also excluded under Article 370. It is the president, the governor, and the council of ministers. That is all. These three are there in Article 370. They can do, undo with the Constitution.
Yes.
And my lords, learned judges talk to each other is always mysterious to us. They don't share their views to us, so that we can answer them.
It's the same way.
Positive, negative, or their response.
Sometimes the same way with lawyers talks that not necessarily everything is.
So, I'll just indicate to your lordships now the constitutional autonomy of the state, which still was intact, which is important because that's what we're striving at. That please help us to maintain this constitutional autonomy. What has happened in the past, and also what kind of governments we'll have in future. It is for them to extend these laws to us. But we need our constitutional autonomy. Now, what is it that we had prior to 5th of August 2019? One, your lordship may have a look at this 1954 order, which is the basis of the order because all other orders have subsequently been amended. And I worked on that and I will show the kind of amendments made under various council orders from time to time. Let me begin with 1954 order.
What page, Mr.?
It's volume 3, page 13. Volume 3, page 13.
Sir, I think you also need to compare it. What is it that was done simultaneously with the Constitution of India? Yes.
To see
That is Constitution Application Order 14th May 1954. Is volume A, volume 3, page 406. General page.
1954. 1954.
Yeah, 54.
PDF page 30.
PDF page?
30.
PDF page 13. In exercise of powers conferred clause 1 of Article 370 of Constitution, the President with the concurrence of the Government of State. Is pleased to make the following order. This order may be called Constitutional Application Jammu and Kashmir Order 1954. It shall come into force on the 14th day of May 54 and shall thereupon supersede Constitution Application of Jammu and Kashmir Order 1950. But I may remind here, this is the stage when Constituent Assembly of the state was in session and was making the Constitution of the state. The provisions of the Constitution, which in addition to Article 1 and Article 370, because that is already stated in 370, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. The preamble remains as it is. Part 1 remains as it is, but to Article 3, there shall be added the following further proviso. I wait here, also just have a look. What does Article 3 deal with? It deals with formation of new states and alteration of areas, boundaries, or names of exist. Parliament may by law form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either house of the Parliament except on the recommendations of the President, and unless where the proposed contained in the bill affects the area, boundaries, or name of any of the state, the bill has been referred by the President to the legislature of that state for expressing its views thereon within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified allowed is expired. Explanation why in this article clause A to E, state includes a union territory, but in the proviso state does not include a union territory. Explanation 2, the power conferred on Parliament clause A includes the power to form a new state or union territory by uniting a part of any state or union territory or to any other state or union territory. Now, my lords, insofar as the order is concerned, to Article 3, there shall be added the following proviso, provided that provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. This is the restriction imposed with regard to the power of the President and the Parliament to do away with the boundaries, the names of the various states. Then, sir, your Lordship will kindly see 7. The right of citizenship of certain migrants to Pakistan, notwithstanding anything in Article 5, and a person who has after the 1st day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now including Pakistan, has returned to the territory of India under the permit for resettlement or permanent return issued by or under the authority of any law, and every said person shall, for the purpose of Clause B of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. That your Lordship will see now what is added to it. To Article 7, there shall be added the following further provision, namely provided further that nothing in this article shall apply to a permanent resident of the state of Jammu and Kashmir who, after having so migrated to the territory now included in Pakistan, returns to the territory of that state under a permit for resettlement in that state or permanent return issued by or under the authority of any law made by legislature of that state, and every such person shall be deemed to be a citizen of India. It's altogether a different provision. The law power to provide for resettlement vests in the legislature of the state, and such person shall be deemed to be a citizen of India. This is the modification made in 7. Then, sir.
Mr. Zapasha, is it because part of the Valley, a part of Kashmir remained in Pakistan occupied? Was that the reason for this basis?
Sorry, I could not see.
Was the reason for this, as you are saying this is different, that a part of the state remained occupied by Pakistan? So is that the basis for it? Because there may be people who may be there and may be coming here. Is that the basis for this?
Not only that, there could be something more. Prior to 1947, there were many areas like Gilgit and other areas where the people of the state who were working under the king were transferred. I know a case that happened to me. They were transferred. An engineer was transferred to Gilgit. Then 47 happened. What do we do with him? This provided a method that if you want to come back, originally he was the citizen of this country. If you want to come back, you will do so only under the Resettlement Act, to be passed not by Parliament. In the case which I read to you, also it's the Parliament which is the power. Here, the power vests in the state legislature that he can come back under this resettlement. So all those people, and important thing is, they shall be deemed to be citizens of India. Means they have not abandoned the citizenship of this country by dint of having been posted there or dint of being there prior to the partition of this country, prior to the part having been taken by them. Of course, that would include that also. The people who got separated, who are now with the Pak-occupied Kashmir, of course, the people who still have relationships in Kashmir, those are across the border, they are here. Those are the practical problems faced by the governments, social problems, people's human problems. They wanted to come back. Somebody wanted to die. I know many cases in Kashmir that happened in the High Court. They wanted to die in Kashmir, but they could not come. This Muzaffarabad road was opened. They wanted to come. It then got discontinued for political reasons. So therefore, this kind of a provision only enabled the state legislature to make the law. If they want to come, of course, subject to the conditions of that law. Whether you have voluntarily given up the citizenship of India, then you cannot come. But if you are by dint of a situation and the circumstances, you are stuck up in another place and you want to come back, After the things become normal, obviously a person cannot come when there is a conflict. When peace is returned, you can come back. Nothing is wrong with you. That you never intended to stay there, but because of certain circumstances. So I would say this kind of a power, all I'm today indicating, Lordship, is the power, what we call as constitutional autonomy, which I have. It is in that context I'm saying, here I have the power to make the law.
Was large number of certificates issued just as a matter of
That
information
was
free.
sometime that was made. I remember that, Your Lordship is.
But
Yes,
they issued some of them.
yes, yes. Actually, then, sir. And it has solar काम हो जाता. S2 and S3 does not. Then will also may kindly see this part 3 of this order. Now it talks of some of the, I may not read them with regard to Article 16, to whom it will apply for a period of 5 years. That is what is important. And then in 4 and 7, that is the case which went to the Supreme Court in Sampak Prakash and other cases. In clause 4 and 7 of Article 22, for the word parliament, the word the legislature of the state shall be substituted. Now see what is this 22, 4 and 7. Four talks of no law providing the preventive detention shall authorize the detention of a person for a longer period than 3 months, unless an advisory board considers persons who are or have been or qualified to be appointed judge of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient cause for such detention. Provided nothing in this subsection shall authorize the detention of any person beyond the maximum prescribed by the law made by Parliament under subclause B of clause 7, or such person is detained in accordance with the provisions of any law made by Parliament under subclause A and B of clause 7. When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall as soon as may be communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. Nothing in clause 5 requires the authority making so as to refer in that clause to disclose fact which such authority considers to be against the public interest to disclose. Parliament may by law prescribe the circumstances under which and the class of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4, the maximum period for which any person may in any class of cases be detained under any law providing for preventive detention, the procedure to be followed by an advisory board in an inquiry under subclause A of clause 4. Now see, sir, what it says. In clause 4 and 7 of Article 20, the word parliament, the words legislature of the state shall be substituted. So the law of preventive detention can be enacted only by state legislature, not by parliament. I must make one thing clear here, sir. Some of the laws may be in a sense duplicate copies of the central laws. Just duplicate copies of this, maybe full stop, commas. But what is important is the power to make the law. It may be, state legislature could make the same law as it did, as this preventive detention law is applicable in the rest of the country. But the question is on your power. We say that this power exists only in the state legislature to make the law of preventive detention, and that is how Public Safety Act has been enacted in the state of Jammu and Kashmir. It is that power which matters. Otherwise, laws may be the same. It's possible. Like we had Ranbir Penal Code, we used to call it. In the rest of the country, they called it Indian Penal Code. The difference was in the name. But the question was only a power. Our legislature could amend RPC, what we normally use called a Ranbir Penal Code, but obviously it cannot amend IPC, Indian Penal Code. Provision may be identical, provision may be same. But what is important to be considered, the power to make that law, the power to amend that law, the power to repeal that law. It is that power which gives us constitutional autonomy. 31. Issue 31. चलो पुरानी किताब निकालो, वाला इसमें 31. February 29. इसमें भी मिसिंग है. मेरा उसमें मेरी फाइलों में जरा इसमें निकालो. ये मेरी इसमें कॉन्स्टिट्यूशन ऑफ इंडिया होगा.
Yes.
So then we have this Article 31, which was in existence at that point of time. I have a copy of the original constitution as it was adopted in 1949. You also will not have this Article 31 in the book, which now is because it stands repeal deleted, and we are now instead of 300A is a ceased to be fundamental right. But I just read it from the original constitution. No person shall be deprived of his property save by authority of law. No property movable or immovable, including any interest in or in any company owning any commercial or industrial undertaking, shall be taken possession of or acquired for public purposes under any law, authorize the taking of such possession or such acquisition, unless the law provides for compensation for the property taken possession of or acquired, and either fixes the amount of the compensation or specifies the principles on which and the manner in which the compensation is to be determined and given. No such law as is referred to in clause 2 made by the legislature of a state shall have effect unless such law, having been reserved for the consideration of the president, has received his assent. If any bill pending at the commencement of this constitution, the legislature of a state has, after it has been passed by such legislature, been reserved for the consideration of the president and has received his assent, then notwithstanding anything in this constitution, it is there. They have it?
Yeah, they.
Okay. Your Lordship also has signed that small book.
Yes.
Oh, yeah. If any bill pending at the commencement of the Constitutional Legislature of a state has after been passed by such legislature been reserved for the consent of President and has received his assent, then not telling anything in the Constitution, the law so assented to shall not be called in question any court on the ground that it contains provisions of clause 2. Nothing in clause 2 shall affect the provision of existing law other than a law with the provision of clause 6 apply. The provision of any law which the state may hereinafter make for the purpose of enforcement levying any tax or penalty or for the promotion of public health or the prevention of danger to life or property or in pursuance of any agreement entered into between the government of the Dominion of India or the government of India and the government of any other country or otherwise with respect to property declared by law to be evacuated property, any law of the state enacted not more than 18 months before the commencement of this constitution may within 3 months from such comments will be submitted to the President for his certification, and thereupon if the President by public notification so certifies, it shall not be called in question any court on the ground that it contravenes the provisions of clause 2 of this article or has contravened the provision of subclause 2 of section 299 of the Government of India Act 1935. Now, see sir, this clause 5 has been substituted under this 54 order. It says nothing in clause 2. First is in article clause 3, 4 and 6 shall be omitted. So we have omission with regard to the power of the parliament. That if I pass a law, it was to be reserved for the assent of the president. I don't have to do that. Our state legislature has not to do that. This gets deleted.
Really trying to say is that under the 1954 CO, there were extensive amendments which were made to the adaptations or modifications were made to the Indian Constitution. There are provisions which were deleted, other provisions which were applied with modifications. In fact, interestingly, Article 136 was omitted.
Yes, 136 is omitted. So what I'm trying to
So
say.
we get that point. We get what does that lead us up to actually?
What argument is this? That when we have a bird's eye view on 1954 order, there are some smaller matters which are matters of internal administration. Then there are some fundamental ones. Like I read, for example, the proviso to Article 13, Article 3, that you cannot alter the boundaries.
Yes.
Now that is a fundamental concurrence between the two governments. I read Article 7 with regard to the permanent residence. That's something fundamental in 54 order. So what I am trying to show is that there are orders which go to the very root of the matter and which continue to remain as they are till date. They have not been diluted. Subsequently, other provisions like 356 subsequently applied, 136 subsequently applied, but they are matters between the union and the state. But then on the broader parameters, the state continued to have its autonomy. That's all I am trying to indicate. By virtue of each and every, I have noted each and every article. It deals with what was the subject matter of the article in the Constitution, and how by the order of 1954, a certain position, especially for Jammu Kashmir, was carved out.
Mr. Shah, can you just, to sort of summarize, can you tell us on the eve of the CO of 5th of August 19, which were the key provisions of the Constitution to which an exception still existed in relation to Jammu and Kashmir?
So let us say Article 3.
So we can really summarize those because that will give us the net position as on the date.
Very true, sir.
There's two ways of looking at it. We can look at the chipper way, or we can look at it from your perspective, which were the core which was still left intact and which now the abrogation completely, sort of.
It is also a full chart. That what?
35
That what was the position on 4th of August 2019, even after application of these constitutional application orders? What was the position as on that date? That's what your lordship wants to know.
Yeah.
This, some of the articles which I read,
every one of those provisions which was modified as on 4th of August 19, if you can give us the core to sort of buttress your argument that look, despite the chipping away, this core had remained intact as on 4th of August 2019.
Very true. I can give that. We still had some autonomy. I'll give some fundamental. Let's say 1997. We may not go that far also. I can give example of the best example 1997. Who had the residuary power? Who had the residuary power to legislate?
Interestingly, both the state list and the concurrent list were deleted in application to the state of Jammu and Kashmir. You'll find that, I just saw it a little while back.
That's what I think it is
part 11, see page 16. Page 16 of volume 3, if you're on the same volume.
Yes.
It says in Article 246, the words brackets and figures, notwithstanding anything in clause 2 and 3 occurring, and clauses 2, 3, and 4 shall be omitted. So basically what happened was, in relation to the state of J&K, you had only the union list which was existing. Insofar as it applied to the state of J&K, the entire state list and the concurrent list had been deleted.
But subsequently, you should also see the...
Thereafter, maybe some items in the state list were brought in, maybe the concurrent list was also brought in.
I think it also needs to give me some time. It is also subsequently changed in CO 66. This 246, which is also read, clauses 2 and 3, occurring in clause 1 to be omitted. That was the original one. 3 and 4 is also omitted.
So really speaking, we therefore take it, Mr. Shah, that we don't have to go through these articles to buttress your point, but your contention is that there was a very substantial degree of autonomy which was reserved to the state as a consequence of Article 370. That was not merely with reference to enacting laws, which we saw in clause 1, but it was also in relation to other provisions of the Constitution, which would not apply unless there was a concurrence of the state.
I thought I would indicate in specifically, one would be a general position of law, that there was a constitutional autonomy with you. What earlier it was, if I put it in terms of quantum, if it was something like 100 grams, but even then I retained 30 grams by the time it was 4th August.
Perhaps, Mr. Shah, what you can do is, maybe without us going into it right now, later on, even after your argument is concluded, you can give us the core areas which had remained for the state as on, the original Constitution.
Specific area, right? I can do.
You can give it to us as of, say, the 1954 order.
Yes.
And then you can give us what still remained with the state as on 4th of August 19. So we can have a comparison. Yeah, you can do it in 2 pages, that's all. Don't give us a very elaborate statement. That will buttress your point. So we appreciate it. That's all that we...
I had done it my way. I had done it specific article wise. Each and every article, that's what I was trying to show. But if you also want me to give it writing, I will give that.
I think just, on a page, one page of the position as it stood in 1954, one page is the position as it stood on the eve of the abrogation. That will really support your submission.
But I'll give that.
So that we don't have to then read individual articles, unless there's something key that you want us to see,
What's important is this, as I said earlier, why are we aggrieved of 5th and 6th? If nothing was with us, why are we aggrieved? Why are before 22, 25 petitions have been filed? There was something with us. I was trying to show what is that was with us. Otherwise, if there was nothing with us, it would not matter. It was an empty formality.
There was something with you, and there was an emotional context to it.
Whatever little, sir, I had with me as a constitutional autonomy, whether they could take it away.
No, that's why I said 2 things: emotional context and something which remained, actually also remained.
True. What I'm submitting is only, in response to only Chief Justice's observation, that you indicate only what kind of autonomy you had on that date, on 4th of August. I will certainly indicate that.
And even earlier, because that will support your submission.
This was earlier what I had in 54. Is it also willing to go into the question that 54, what you got, and over the subsequent CO orders, what you lost at what state? I can take one by one your losses on that. what I lost subsequently, but ultimately it ended up on 4th.
Yes.
But if what you say is on
You're
4th,
ultimately
what autonomy
concerned
you
with-
had to indicate that, I will do that.
On 4th August,
I did have
as
my autonomy.
370
on 4th.
stood, what is that which were with you, which you have been denuded of by repeal of this?
So take it on the face of it, I can say so just from my heart without supporting it. Let's say, I was a permanent resident of the state. I had my own law. I had own privileges, own rights. Isn't that taken under? It's as simple as that. Just to your lordship's knowledge. As simple as that. My state could not have been divided into union territories. Isn't that taken away? Honorable the Chief Justice says, you tell me the solid ones which you lost, not the other things appeal to Supreme Court or otherwise. These are few of the solid ones which come to one's mind. I lost that. I lost my legislature, lost the power to make the laws in respect of those matters where it had the power, maybe little power, but it had the power, particularly entry 97. It made certain laws, it made certain changes, but now that is also gone. Preventive Detention Act is also gone. We'll also have seen the Reorganization Act, how many laws have been repealed? Consequent to
Mr. Shah, to buttress your submission, we are saying something, which will enhance, which will further your submission. Just look at page 16 of volume 3, in case, I don't know if you are using the same, we are on the same page.
I'll just have a look.
Volume 3, page 16.
1/6, sir. Just
1/6.
I have mine. This digital.
No, somebody can give that.
Yes, sir.
So that we are on the same page.
15 or 16?
Page 16, you've got that middle of the page, part 11. Part 11.
Oh.
PDF page 16.
Yes, sir.
Right? So part 11, right?
Yes, in
A.
Article 246.
In Article 246, the words bracket
not
figures
2 and 3, article so and so shall be omitted.
and clauses 2, 3, and 4 shall be omitted.
Yes.
In other words, Article 246, which recognizes the power of the state legislature to enact laws on the state list, and the power of Parliament to enact law on the concurrent list was deleted in 1954.
Yes.
Now, just go to page 19, PDF page 19. Go to the 7th schedule, page 19, you will see entry 22, 7th schedule. Just give Mr. Shah the page, Mr. Shankar.
19, yes, was CO, this is CO 55?
No, 54. We are on CO 54 only now.
Just one minute, I'll show you.
3 pages down, just turn to where the schedules are listed.
7th schedule, yes.
In the union list,
Yes.
just go a little down, item 2, where it says entries so and so, the words interstate migrate and entry 97 shall be omitted. Therefore, entry 97 is completely omitted.
Yes.
Now, go to the last clause of 22B. The state list and the concurrent list shall be omitted.
Yes.
So, the net result in 1954 was Parliament had the power to enact laws with respect to some entries in the union list.
Union list, yes.
The entire legislative domain of Parliament on the concurrent list was obliterated, and the state list was also deleted because the entire power of legislation, the legislative power, was given to the state legislature. This is the autonomy which you are saying,
Yes.
isn't it?
This is what I could specify also what was left. My last question is very extremely important. What was left on 4th of August? I said.
Now we'll go to the 4th of August because that's the part, the chipper way there.
What the chief is pointing out in a larger conspectus, what you are saying is 54 reflects a larger conspectus. Larger conspectus is that list 1 as specified, list 2 omitted, list 3 because list 2 already vested with you. Thereafter, as you say, chipped over. So this gives the larger, in support of your argument, the larger context of it.
No, if I am satisfied, not me, your lordships are satisfied that on 4th of August, there was constitutional autonomy, some constitutional autonomy. What was its quantum? How much it was is a matter of detail.
Reflected it at lunch, you're almost in the stroke of lunch. One way of our doing it is, after the 1954 order, read every order and see the chipping away process.
That
That will unnecessarily take a lot of time and it will be tedious. What we were suggesting was that you can give us the net position as it stood on the 4th of August 2019. So we'll realize then, we've now seen the 1954 order, which gave a very substantial autonomy. No doubt about it. That point you've made. We need to labor the point further. Now we look at what was the position on the eve of the abrogation, which is 4th of August 19. Because your argument will be that even as on the 4th of August 2019, notwithstanding all the subsequent applications which took place, there was still a core left with the Jammu and Kashmir State Legislative Assembly. So you can give us, like we have now done for 1954, some 3 or 4 examples, and you can put the rest on a piece of paper, just sort of putting it all together.
I can put it entry-wise, this entry, this entry, this something, that I can do.
But just confine it to the key areas, because that will buttress your point, isn't it?
That's the problem, which is a key area.
No, I mean,
I have some
where the rub lies.
States being together, unified state is a key area. Who is a permanent resident is a key area.
right.
These are the key areas.
So can you just summarize them after lunch for us? Which are the key areas, so that then we can move on to the rest of the argument.
I'll do that. So that
Got the drift of the argument. We just thought that we should have some illustrations, which are the key illustrations that will sort of, drive the point home.
unless your lordship were writing the judgment would be very specific. Look here, the state still enjoyed its autonomy in respect of A, B, C, D. That's being specific.
Right.
Second would be also would say they did have some.
What has been
What
taken away by the under the provisions which are under.
What has been taken away? What was left with us? What would be general statement making? Sir, I had, as I tried to give example, 100 grams with me. They took 70, 30 still with me. But what was that 70? What was that 30? I thought that I would deal with it in more specific terms. This is taken and this is with me, rather than being general about it. That's what I was trying to.
The only thing is time in all this becomes a little constraint. Now, yes, there was a position in 1954. We've understood your position in 1954. That at various times to time something may have been chipped away.
Yes.
Is there when and how is not before us. Because that's a post facto situation.
Yeah, very true.
As you also argue.
Very
Now, something happened which is under challenge. So,
Yes.
a pre-challenge position for us to appreciate what was the pre-challenge situation which has been deprived in the result of what you have challenged.
Yes.
So,
Yes.
this was
I'm
not
with your lordships. I'm with your lordships.
We have understood your broader arguments on consultation and concurrence. Now we just would like to know what was the residuum which was left on the eve of the
What
abrogation.
was left of constitutional autonomy? It was in simple language.
As you said,
What is left of constitutional autonomy?
there was something left. What is that something is the only thing we are wanting to know.
All right, we'll just look at it after lunch. And just, yeah, one people will make look.
Part 6 was not applied.
Go ahead. Mr. Shah, now what is a rough time estimate for you to complete?
I need to still argue, so I have some problems I need to argue.
About, should we give you another hour or so? Can we wrap up in an hour so that then
No,
the
sir,
next
it will be
person?
more than that. It will be more than that. I would regret it might spill over even because I have some more to say.
I know all of you have some things to argue. Our constraint is also at some stage things have to end.
Give me that little freedom.
All your ability, I'm sure you can. With all your ability, you can.
Important case for us.
Of course, we understand. That's why we are giving so much of time.
And
Of course, Mr. Shah, no
freedom
doubt
to
about
give-
it. Mr. Shah, can we do this? Can we suggest this after lunch? You can give us broadly the themes on which you are going to argue. Just formulate the themes so that we also have a clear picture that how you are now going to unfold the rest of the argument. Just give us the 3 or 4 themes that you're going to argue and show us under that theme. Then we'll know what exactly you are.
As you know.
That will be better.
All right.
Thank you.
Thank you.
photo, yeah.
Testing 1, 2, 3. Check, check. Check, check, check. एक सेकेंड check, 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 check. Audio check. वॉल्यूम अप डाउन करो एक बार. डाउन करना. Check, check. start and mute. Check. check. Audio check.
Yes. So I think now we'll focus on each of these themes. The first one you've actually covered, I think.
The permanent nature of
Yes.
Article 370.
Yes.
Except few sentences I would like to use. One is that when it was originally enacted by the Constituent Assembly at that time, they rightly termed it as temporary. Rightly. Because at that point of time, the position of the state of Jammu and Kashmir was totally unclear. As I said, it had an external dimension and it also had an internal dimension. The external dimension was because of UN Security Council resolutions, and the internal dimension was because of the letter of Governor General dated 27th of October, 1947. So therefore, the Constituent Assembly thought that the Constituent Assembly of the state would recommend application of the Constitution of India directly to the state of Jammu and of course, through Article 370. They proceeded on that assumption. I am entitled to say so that this was an assumption made that the Constituent Assembly would do. Materialize, could not actualize. This is the reason I'm giving. So this continued, this position continued till 1957. Since the power vested with the people, as also under instrument of accession, as also under proclamation of Maharaja, had three sources to make the constitution. Therefore, the Constituent Assembly made a separate constitution for the state of Jammu and Kashmir.
Which were the three sources you said? The instrument of accession?
One was instrument of accession. Second was proclamation of Maharaja of 1948.
Yes.
Now, when it adopted,
And which was the third?
what I said was this letter of 27th of October 1947
Yes.
of the Governor General. Now, since the fate of the state was uncertain, therefore they left it temporarily. It could be a part of union, it could not be a part of union. But in the meanwhile, the constitution of the state was made. Now we are again concerned, those are the political aspects of the matter, what happened at that point of time. I'm not going to that question on, my lords are going to adjudicate those issues. But the fact of the matter is that right from 1951 till 1957, when constitution was made, so we, at the end of 1957, in fact, January 1957, now we got two. One was the Constitution of India as was applicable to us, and second was our own constitution. This is the situation in 1957, and this is the source of the constitution of the state of Jammu and Kashmir. Now, what is contained in the constitution of Jammu and Kashmir could not also be contained in the Constitution of India, that they would be in conflict. So therefore, all those provisions of the Constitution of India, which could come into conflict with the Constitution of Jammu and Kashmir, were not made applicable to the state of Jammu and Kashmir. Now, few of them which are extremely important as we proceed ultimately to determine the constitutional validity of the action taken on 4th. My lords, may have a look at the Constitution of Jammu and Kashmir. Page क्या उनका क्या volume? M2. My lords, in volume 2.
Is it page of volume 2? The first have you referred?
So 232, general page. Volume 2, 232.
PDF 232?
PDF. PDF 7.
Yeah.
Now, this constitution is given by the people of Jammu and Kashmir. The Constituent Assembly was constituted in terms of the notification of the then heir of the king, that is Dr. Concurrence, on 20th of April, 1951. And in terms of that notification, which is also part of my Lord's records, elections took place on the adult franchise. People's representatives were elected and they became the members of this Constituent Assembly. Now, what did the Constituent Assembly do? It ensured, if I generally say it, it ensured that the state of Jammu and Kashmir shall continue to remain the integral part of India. So on that part, it is there. Second thing, it ensured that the provisions of the Constitution of India will be made applicable to the Jammu and Kashmir. Two provisions there, Section 3 and Section 5. The Lords will have a look at Section 3. It says state of Jammu and Kashmir is and shall be an integral part of the Union of India. Page 18. PDF. The 4 is territories of the state. 5 is extent of executive and legislative power of the state. The executive and legislative power of the state extend to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. Now read this with Article 370. Means the state legislature will not have any power to make the law if Parliament of India has that power. But where from the Parliament of India will get that power? Only with the concurrence of the government of the state under Article 370. Five, the executive legislative power of the state extend to all matters except those with respect to which Parliament has power to make laws for the state. So laws for the state to be made by the Parliament was dependent upon the concurrence to be given under Article 370, except those which were in the instrument of accession. Consultation was required there. It was dependent. So this 5 we need to read with Article 370 and the power of the Parliament which is given to it. So all other powers which were not, in respect of which no concurrence was given under Article 370, obviously the Parliament would have no power to enact laws, and the power will vest in the state legislature in terms of Section 5 itself. This is how we read how Section 5. Now, provision is also made of permanent residents. How does this get protected? This gets protected by the proviso to Article 7 of the Constitution of India. Then, sir,
yes.
Seven is construction of reference to state subjects and existing laws, legislature to define permanent residents, special provision for bills related to permanent residents. Now come to 10, rights of the permanent residents. The permanent residents of the state shall have all the rights guaranteed to them under the Constitution of India. Now it gave them the rights which were available under the Constitution of India. And for permanent resident, he had to be a citizen of India first. After 1954 application, he had to be a citizen of India first. Then only he could be a permanent resident. During the Maharaja's time, 1927 notification and 1932 notification had nothing to do with being a citizen of India, because at that time, India as such did not exist. So therefore, they were brought, these two notifications which are protected under this constitution. They carried a condition with it that you have to be a citizen of India, then only you can be a permanent resident. And their rights would be those as are available under the. Now look at now directive principles of state policies. Now, the provisions in the Constitution of India relating to direct principles do not apply to us because the state constitution has its own direct principles. Now comes the important part, that is part 5, exec to the governor. This part is extremely important in a certain perspective that I will indicate, which is one of the arguments which I propose to raise. Now, who is the head of the state? It says the head of the state shall be designated as the governor. There was a change earlier, it was first Maharaja, then Sadr Riyasat, now it is governor. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or throughout subordinate to him in accordance with this constitution. Nothing in this section shall be deemed to transfer to the governor any functions conferred by any existing law on any other authority or prevent the state legislature from conferring by law functions on any authority subordinate to the governor. Appointment of governor. The governor shall be appointed by the president of warrant under his seal, hand and seal, provided that the person holding office as Sadr Riyasat immediately before the commencement of the Constitution of Jammu and Kashmir 6th Amendment Act shall on such commencement be the governor and shall subject to other provisions of this Constitution continue to hold office as governor until the remaining period of his term. The governor shall hold office during the pleasure of the president. The governor may, by writing under his hand and at his president, to resign his office. Subject to foregoing provisions of this, the governor shall hold office for a term of 5 years from the date on which he enters upon his office, provided that he shall, notwithstanding the expiry of the term, continue to hold office until his successor enters upon reference. Qualification: no person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 30 years. Conditions of office: the governor shall be a member of either of the office. Governor, he shall be deemed to have vacated his seat on the house in the house on the date on which he enters upon. The governor shall not hold any office of profit. The governor shall not be entitled to shall be entitled to such emoluments. Now, what is important is in this the oath which he is required to take. That is section 31. The governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court or in his absence, the senior most judge of that court available, on oath or affirmation the following form. That is to say, I so and so that I will faithfully execute the office of governor or discharge the function of the governor of Jammu and Kashmir and will, to the best of my ability, preserve, protect and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of the state. And the governor stabbed the people of the state in the back. He committed serious breach of the oath by making a recommendation to abrogate Article 370, which he could not do. Had he been a sitting governor, perhaps impeachment motion could have been moved against him. He is to uphold the Constitution of Jammu and Kashmir, and he destroys it by his recommendation to the president that you apply all the provisions of the Constitution of India to us, which even the Constituent Assembly did not do. He requests the President of India, you change the Constituent Assembly to Legislative Assembly. And the President of India is pleased to accept the recommendations of the governor when he acts in breach of the oath of the Constitution of Jammu and Kashmir, which is serious constitutional misconduct committed by the governor. And in this particular case, there is no evidence produced. Nothing is stated in the counter affidavit. When was the recommendation made? Who made the recommendation? At whose instance the governor made the recommendation? I have a very serious issue to submit before this honorable court with regard to this role of the governor in making a recommendation when the state was under president's rule. Then, sir, seek 35 Council of Ministers to aid and advise the governor. Council of Ministers to aid and advise the governor, section 35. There shall be a council of the chief minister at the head and aid and advise the governor in the exercise of his functions, all functions of the governor except those under, now see this is important, all functions of the governor except those under section 36, 30 and 92 shall be exercised only on the advice of council of ministers. Means that he had a subject to satisfaction in respect of three provisions, 36, 38 and 92 and none else. He cannot act of his own. Under any provision of the constitution of the state, and much less he could act under Article 370 in making recommendations to the president. And this governor has been spilling beans all over the country. According to one of his press statements, he was asked to sign on the dotted lines. That you also will find from the records because we have no access to those records. (36) is the appointment of ministers, responsibility. Then appointment of Advocate General, conduct of business. Now composition of the state legislature. We have the seats reserved for the territory which is occupied by Pakistan in section 48. Can you see this? We have then composition of the Legislative Council. We had a bicameral legislature, Assembly also and Council also, that is section 50. Then Caesar 51. Qualification for membership of the legislature. A person shall not be disqualified to be chosen to fill a seat in the legislature unless he is a permanent resident of the state. They alone can be the members of the legislature. Then so directly kindly go to section 92. Obviously, these provisions are not in the Constitution of India. If at any time the governor is satisfied that the situation has arisen in the government of the state cannot be carried on in accordance with the provisions of this Constitution, the governor may by proclamation assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by anybody or authority in the state, make such incidental and consequential provisions as appear to the governor to be necessary or desirable for giving effect to the objects of proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to anybody or authority in the state, provided that nothing in this section shall authorize the governor to assume to himself any of the powers vested in the High Court. Any such proclamation may be revoked or varied by subsequent proclamation. Any such proclamation, whether varied under sub 2, shall accept when it is revoked and cease to operate on the expiration of 6 months from the date on which it was first issued. If the governor by a proclamation under this section assume to himself any of the powers of the list to make laws, any law made by him the exercise of that power shall subject to terms thereof continue to have effect unless 2 years have elapsed from the date on which so and so. No proclamation under subsection 1 shall be issued except with the concurrence of the President of India. Every proclamation under this section shall, except where it is a proclamation revoking a previous proclamation, be laid before each house of the legislature as soon as it is convenient. Now, what's important in this is the same thing as in Article 356. that when you cannot carry on the government in accordance with the provisions of the Constitution. That is the subject of 92, and that's also the subject of Article 356. Now, the question for Lordships is that on the basis of pre-existing Constitution, if the government cannot be carried on, whether the Constitution itself should be changed, or you have to see only that the government is not being carried on according to the Constitution, which was prior to any alteration or change made in the Constitution. My submission is that nothing can be done when 92 is in operation or 356 is in operation, because the subject is only that governments cannot be run according to the Constitution. But no power vests in any authority to amend the Constitution, whether it is 92 or 356. None. Just on an analogy, I'll just seek your Lordship's consideration to Article 34. Of the Constitution of India.
So 34.
34, yes. Just by way of analogy, I'm showing. Notwithstanding anything in the foregoing provisions of this part, Parliament may by law indemnify any person in the service of the Union or of a state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where martial law was in force. Or validate any sentence passed, punished, inflicted, forfeiture, ordered, or other act done under martial law in such area. If such a situation would arise, would this court countenance that the chief martial law administrator will abrogate the Constitution of India because it doesn't suit him? What is the power with it? I'm trying this as an analogy that even if there would be a case of martial law, the Indian Constitution, the Constitution of Jammu and Kashmir, do not contemplate, envisage, nor can be conceived of that during the operation of 92 or 356, any change in the constitutional relationship can be made. That's my contention of the Lordship's consideration. Then, sir, in our state constitution, it is 93, that is the High Court, appointment of judges, qualification of judges. All those incidental provisions are provided. And if the transfer is to be made, the concurrence of the governor of the state has also to be obtained upon a transfer of a High Court judge to the High Court of Jammu and Kashmir. That was the position prior to 4th August. Then our High Court had its own power of issuing the writs under section 103 and 104. Then, sir, we had our own Public Service Commission in terms of section 124 with all incidental provisions related to the members. Then 126, which corresponds to Article 311, giving protection to the government servants. That was also there. So these were the different provisions. Now we come to the, which reference has been made, 147. Official language, Academy for Development, protection of governor, all those provisions are contained in the Constitution of India. When we see 147, an amendment of this Constitution may be initiated only by introduction of a bill for the purpose of the Legislative Assembly, when the bill is passed in each house by a majority of laws less than 2/3 of total membership of that house, it shall be presented to the governor for his assent. And upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill, provided that a bill providing for the abolition of the Legislative Council may be introduced in the Legislative Assembly and passed by it by a majority of the total members of the Assembly, by a majority of not less than 2/3 of the members of the Assembly present and voting. Provided further that no bill or amendment seeking to make any change in, the word amendment is not there, but seeking to make any change in this section 147 itself, the provisions of 3 and 5, or the provisions of the Constitution of India as applicable in relation to the state. Now, this is relatable to clause D of Article 370, which provides for the application of the constitutional provisions with or without modifications. It means it prevents the state legislature from making any change in that relationship. दे दो पहले निकाल CO273 CO273 page 496 volume 4 496
Argued covered, I think, item, your submissions 1, 2, 3, 4, 5. The first 5 themes you have covered, I think.
Yes, sir.
Whether Article 370 has become permanent with the passage of time. 2, whether the autonomy of the state is to be determined not only by the laws applicable to us, but also by the Constitution of J&K. 3, whether CO 272 is constitutionally valid because the state was under precedent's rule and no change in the constitutional relationship could be made when presidential rule is in operation. 4, because the Council of Ministers not being in place, no recommendation can be made by the governor. 5, no evidence produced with regard to the recommendation of the Council of Ministers or the governor who acted in breach of his oath and was thus liable for impeachment.
These are the themes, pursuant to the law's observations, but they need to be expanded.
But you have now shown us in the last
something more to show.
Last 35 minutes, you have shown us now the first 5 themes, I think.
In this, your Lordship, kindly have a first look at page 496, that is CO 273.
Which volume? Same volume?
That is the second notification.
Volume 3 page. The 6th of August, 19.
This is in continuation to what I am submitting. All provisions of this Constitution, this is the resolution of the Parliament, sent to the President, and there's a declaration issued by the President. But what is done under this is important. I'm reading it for that purpose. I have different arguments to make. All provisions of this Constitution as amended from time to time, without any modification or exceptions, shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in. Now, this is important, what has been taken away. Article 152, Article 308, or any other article of this Constitution, or any other provision of the Constitution of Jammu and Kashmir, or this is any law, document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom. Something is wrong with this subject one. Regulation, notify, custom or usage having the force of law in the territory of India, or any other instrument, treaty or agreement as envisaged under Article 363 or otherwise.
What would be your submission? How will you formulate your submission on this aspect?
I'm saying this, that what is sought to be done in terms of this was with me.
Sorry?
They do away with my constitution. They do away with instrument of accession.
Yes.
Now, so let's see once again this, my submissions with regard to this CO 272 and 273. That's very important to us because that's where the court is to adjudicate primarily the issue. 272, 273. इसका दिखता ही नहीं मुझे, इसका गायब हो जाता है. So let us take a close up of this 272 first, because in my humble submission,
Same.
One page up.
if 272 goes, then 273 goes, Reorganization Act will go. We'll take a close. In exercise the powers conferred by Clause 1 of Article 3 of the Constitution, the President with the concurrence of the Government of Jammu and Kashmir. Now I'll pause here first. It says Government of Jammu and Kashmir. I have a different meaning of the word Government of Jammu and Kashmir. If you also have a look again at Article 370. Explanation: for the purpose of this article, the government of state means the person for the time being recognized by the president on the recommendation of the Legislative Assembly of the state as Sadr Riyas and Kashmir, acting on the advice of the Council of Ministers of the state for the time being in office. Now this Sadr Riyas gets changed into governor by an amendment not carried out in the explanation, but carried out in the Constitution of Jammu and Kashmir, 6th Amendment Act. What I'm saying is this expression on the aid and advice of the Council of Ministers. I pause here. When we're using the word government of the state, the Article 370 and its explanation defines as to what is meant by government of the state. A government of the state can exist without Council of the Ministers. In the normal parlance language, we say this is a government of the state. There may be a Council of Ministers or not. But what 370 envisages is a government of the state which is aided and advised by the Council of Ministers, not simply sit a government of state. Government of state is there always. Emergency, no emergency, president's rule, no president's rule. The government of the state is always there. But a distinction is made in Article 370. It is that government of the state which has the benefit of the aid and advice of the Council of Ministers. And I consider this to be the extremely important part of the power to be exercised by the governor as the head of the state in making any kind of recommendation to the president. Admittedly, the state is under president's rule. Admittedly, section 35 of the state constitution is suspended. But what's more important is this, that in terms of the presidential notification, the President of India assumes to himself the powers of the governor, not only under the Constitution of India, but also under the Constitution of Jammu and Kashmir. I have it somewhere. The
President assumed the powers.
Under the presidential notification, the President of India assumes to himself the powers of the governor under the Constitution of India, as well as the powers of the governor under the Constitution of the Jammu and Kashmir. Both. नहीं ना तुम लोगों को है कागज है तुमसे नोटिफिकेशन Volume 3
Amendments to interpretation clause in the 367 made for the first time
When was the 367?
as applicable to the state of
Modified
Jain.
form. That was in 54 order.
54, not afterwards.
Afterward, there was one more occasion, I'll give Lord. So my Lord stopped at me, otherwise I would have given all those details. 367 has its own 3 times.
3 times.
First in 54, thereafter one more time, and lastly under 2000.
No, that last we know.
Meanwhile also there is.
In
Oh,
between.
yes, I do. It is in 1966
Okay. 54, 66,
and 2019.
2009.
Now, why that? No, there's a why part of it, no? In 54, we agreed, and that is stated there. What is important is 66. Prior to 66, in 1965, the Sadri Riyasat was replaced
By the
by
governor.
governor. So obviously, the constitutional application order of 66 said that reference to the Sadri Riyasat
Will be in
would be
reference to the
reference to
governor.
Right.
Why did it say so? Also because this expression Sadri Riyasat had appeared in explanation. That explanation is in the Constitution, Article 370, and it said that you can amend 370 only if recommendation is made by Constituent Assembly. Since in 66 there was no Constituent Assembly, so Sadr Riyasat got stuck up in this explanation. In order to overcome that difficulty, they said read Governor for Sadr Riyasat, but important fact is that first the amendment was carried out in the state constitution. Not without that. Therefore, it became the chief minister, the prime minister became chief minister, Sadr Riyasat became governor. In 65 amendment carried out in the state constitution.
So there was first was 1954,
then 66,
but
then 2000.
1954 also, but in 1954 there was no need for that. Because till 1954, the Constituent Assembly was still in session.
There were Raj Pramukh, there were.
But just till 1954.
Yeah.
And therefore, clause 2 was applicable. Clause 2 to Article 370 was applicable. But still they made the amendment in the definition or the interpretation clause.
My Lord's observation gives rise to one serious question. That is whether 367 also is a source of amendment. Keswanada Bharti can be, you can get rid of it simply by amending General Clauses Act. That the amendment shall include amendment of part 3rd. That is the end of the matter.
We will not go into that. No, that question need not be gone into. Let's put it very.
That question need not be gone into.
One thing is very clear, that 370 was a flexible article. It was always meant to be a flexible article.
When my lords are saying flexible article in this sense.
Yes, but with the concurrence, or that your argument to that effect.
Flexible in this sense, there's a perspective, flexible in the sense that the provisions of the Constitution of India or the lists 1 and 3 could be made applicable to the state. Of course, to that extent, it was flexible, but its own self-abrogation. It is suicide, its own killing. Whether it was possible to do by the government or by some external authority.
You have argued on that.
No, I am still arguing on that. I'm saying it.
There's another point of view also. You have argued because there's another point of view.
Sir, whenever I said that, this case turns on the powers. My lords are interested in power of president, governor. That is the basic theme in all of my submissions. That the power, I'm dealing with the issue of power. Now see, this journal page 485.
Just one second. We wanted 2 amendments to Article 367 have found.
Volume 3. Page number?
38. It says 65. Volume 3, page 18, volume 3, page 39. Those are the 2. Now what next?
Now see, my lords, see this notification. I so-and-so received a report from the governor of the state because 6 months had expired. And under 92, the governor's rule could be only for 6 months. And after considering report, other information is where I am satisfied such a reason in which the government of that state.
Where is that notification?
So I'm reading 19 December 2018 notification. Page.
No?
See, please, sir, Now, therefore, in exercise of powers conferred by 3/5 Constitution, all other enabling, I hereby proclaim. I assume to myself as President of India all the functions of the government of the said state and all powers vested in or exercisable by the governor of that state under the Constitution and the state constitution. Now pause here for a minute. What power the governor had first under the Constitution of India? He is the appointee of the state government, appointed by the president, but functions under the Constitution of the state of Jammu and Kashmir. His qualifications, his emoluments, he takes oath under the Constitution of Jammu and Kashmir.
But holds office during the pleasure of the president.
Very right. Now, when he assumes to himself the power of the governor of the state, this is the important sentence I'm reading. For purpose of 370, now who is governor? Who can make recommendation? If the president says, I am the governor, I have taken all your powers, then for purpose of 370, who has to make that recommendation? That you do away with Article 370. You apply all the provisions of the Constitution. The president himself or somebody else. When the president delegates, that delegation is subject to direction, control, and superintendence of the president. Means the governor is the delegate of the president. Now, is it a case where an agent and a delegate recommends and the principal accepts? Does it commend itself to our sense of justice that where the President of India has assumed himself the power of the governor? I am saying that no power vested in the governor of the state of Jammu and Kashmir to make any kind of recommendation on the basis of which CO 272, 273, 272 was issued. No power vested because it's taken over by the president. And he could not have recommended to himself the abrogation of Article 370. So again.
Yes, Mr. Shah.
So when he assumes to himself this jurisdiction, that's what I'm saying, this, I'm dealing with this case on the basis of the power. When he assumes to himself this jurisdiction, that I am the governor, I really fail to understand then who could make the recommendation under 356. And the opening word of CO 272 is, kindly have a look at 272 once again, sir. In exercise of powers conferred clause on the president with the concurrence of the government of Jammu and Kashmir. That government of Jammu and Kashmir is defined in explanation appended to Article 370. Means the government which has Council of Ministers in place. Why did the Constituent Assembly of India expressly provide it? Sadr Riyasat, aid and advice, governor, aid and advice. It is repeatedly, even under 367 modified form, reference to governor is aid and advice. What is entrapped in this? Because one way of understanding Constitution is simply by the text of it, going by the words. Second is, which I am submitting is for Lord's consideration, is the legal value which is entrapped in that provision. What is the legal value entrapped in this provision of 370? Council of Ministers, if I put it, doesn't it show the political presence of the people? Doesn't it show representatives of the people are present? Doesn't it have the element of democracy that people are there through Council of Ministers who alone are answerable to the legislature? So what is entrapped in Article 370 is not what is textually written. But we need to interpret this 370 in terms of the purpose it has. I'm submitting for Lordship's consideration is that purpose of interpretation needs to be placed on Article 370.
Yes.
So I request your Lordship to have once again a look at CO 272 and for the benefit of Honorable Justice Khanna with Article 367 as it was applied.
Mr. Shah, if you could just, so that will bring clarity to us. We've made our notes when you were arguing. Can you now on this aspect just crystallize your submissions in 1, 2, 3, 4? We'll take it down so that we have it in one place.
No. If I have to go by the...
Because we have seen CO 272, 273, but if you can formulate it so that it bring structural clarity to the whole discussion.
One of the first one which I submitted also was that 370 is a permanent.
No, you need not go that far back, just on this aspect.
I'm just reading to what you gave.
Oh, okay. No, that we have seen. No, I've not done that. What you just said about 272, there if you can just formulate your submissions. Whatever you covered earlier, that we've got very detailed note. This part, if you can just formulate
The challenge to 272.
272, right.
Challenge to 272 as an independent.
Without expanding, the Lordship's giving me the pleasure of being here and hearing in detail. Challenge to 272 is first.
Yes, just a second.
When the presidential order is invoked under 356 is point number 1.
Sorry, can you just come again?
356.
No, can you just start from the beginning? Or when the presidential?
272 is notified, issued at a stage when presidential order under 356 is in operation. Number 2.
Yes.
That the President of India, under notification dated 19 December 2018, had assumed to himself the powers of the governor of the state of Jammu and Kashmir.
Yes.
Number 3, that 272 is issued with the concurrence of the government of Jammu and Kashmir, which meant a government where Council of Ministers is in place.
Yes.
Number 4, in terms of this CO272, all the provisions of the Constitution of India are made applicable. Which could not be done as it had not earlier been done by Constituent Assembly. Or by the government of Jammu and Kashmir, or by the governor at any stage in 69 years. Number 5, when it says that all the provisions of the Constitution of India will apply, it would mean Article 368, which carried a proviso with it, would go, and 368 would also apply.
Can you please formulate that again?
Repeat that again.
So when it said all the provisions of the Constitution of India will apply,
Just 1 second. When CO272 states,
yes, it says all the provisions of the Constitution as amended from time to time, Constitution means Constitution of India, shall apply in relation to the state of Jammu and Kashmir, except the following. That is 367 modified. Who says so?
sorry, what do, I got this part. When CO272 states that the provisions of the Constitution of India as amended will apply, except Article 367 as modified.
Yes.
What is the sequitur?
It means that Article 368 would also apply, which provides for amendment of the Constitution.
According to you, then, as per 272, 370 was not no longer applicable.
Look, it says
That's a sequitur to your argument.
that's the logical conclusion that can be drawn. We want to draw the logical conclusion.
Oh, no.
You want to get.
No, now you're stretching,
No, I'm
you're
just-
stretching it too much.
I am just reading English language. That is all. It is meaning.
You're stretching it.
I'm really trying to find out what is the purpose, what's it leading to.
Very.
How do we know?
No, it tried to
It will
remain.
occupy the text.
Reformulate the last point. I mean, just for doctrinal clarity, because this last point which you made is not really
Clause 2, sir, kindly see clause 2
of.
of this 272.
Just 1 second.
Clause 2, sir.
Small 2, right?
We'll understand it by the text of it.
Small 2.
All the provisions of the Constitution, that is Indian Constitution, as amended from time to time, which amendments have been carried out in the Constitution of India, shall apply in relation to the state of Jammu and Kashmir. Pause here. So entire Constitution, right from Article 1, right from Article 2 to Article 396, all would apply to us. That's all what I'm saying. And in that 368 would also apply.
Yeah.
It would also apply to us.
And,
here we come to
and what happens to 370 then?
So in any case, they have finished 270. That was the intention.
No, that was the
What happened
second,
to
that's the second one. That's a two,
Yeah, I like
not
this.
272,
Yes.
not 270.
They removed the form as well.
Anyway, we
They
were,
removed the form. Now is the 367, kindly see 367. In clause C, reference to the government of the said state shall be construed as including references to the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. Just see this. So under 367, advice of the council is also provided in this 272.
Yes.
Now, when Council of Ministers is not there, yet the governor makes the recommendation. Now see the last part. In proviso to clause 3 of Article 370 of the expression of Constituent Assembly of the state referred to clause 2 shall read Legislative Assembly of the state. We pause here. This is one of the most important controversial part of 367. Now this is being done by the president, who himself was the governor, but mentions it that with the concurrence of the government of the state, he applies 367 in a modified form to us. Now, this is what the learned senior advocates have been arguing, that this 367, whether this can be invoked for purposes of changing the expression Constituent Assembly into Legislative Assembly. That in turn will involve another question: what is this 367? Which is only one of the provisions of the Constitution related to interpretation. It says, unless the context otherwise provides. The provisions of the General Clause Act would apply for interpreting the Constitution. It's in simple language, the meaning of 367. Now, going to the main provision of 367, when it says that if the courts have difficulty in interpreting any provision of the Constitution or any word of the Constitution, then the court is entitled to seek aid of General Clause Act. This is
so really speaking, according to you, Article 367 is only an interpretative tool. And what you have essentially done is, by introducing a new principle of interpretation, you have amended the substantive part of 370.
Also, the first question would be jurisdiction, whether they could do so. This will come later, sir, what they have actually done. We are on the question of jurisdiction. Could the president, on the recommendation of the government of the state, where there was no council of ministers, could he make it? I am on the question of power. This is what I'm saying all the time. Second, assuming he had the jurisdiction to do so, then while exercising that power, could he make an amendment in 370 subclause 3 with the aid of 367? Then the second question is, first is whether he had the power, he himself was the governor. Having delegated the power to the governor, but under his superintendent's control and directions. It's a very peculiar situation which is done, which is, no, we're not seeing such cases. That is why this case involves certain very issues of considerable importance, because your lordship is dealing with a federating state in a union. We're dealing with the rights of a state, not of a single individual whose fundamental rights are violated. The rights of a state are dealt with. It involves about more than 1 crore people. It involves more than 84,000 square miles of the territory. This case is extremely important, not only in this country, but everywhere. That's how this court will respond to what has happened on 4th and 5th of August 2019. This, I would submit, is not run-of-the-mill case, not an ordinary case. We are taking time. I am grateful to lordships only for that. But then the cases of such nature, it involves so many considerations, the historical perspective. Without that, no person can understand 370. If he doesn't, he's not aware of the history of the whole matter. Then subsequently, what the governments have done, and ultimately what it did, just like the governments were allowing constitutional application orders, but somebody wanted to have all the golden eggs in one go. So they killed the hen on 4th. The governments were for last so many years giving concurrences, consenting to it. You apply this order, this order, this order, 54 in number. Somebody thought we got to kill the hen and get all the golden eggs.
All right, we've concluded this part now. Can we move on to the next part?
What I'm submitting is that this was patently without the jurisdiction of the president, and he is acting as the governor.
So you have challenged it on both counts, absence of power, and assuming the power did exist, the exercise of the power by seeking to amend Article 367.
Now, as a consequence of it, why I said this is the most important notification. As a consequence of it, when you change Constituent Assembly to Legislative Assembly, then things become, you have paved way for getting rid of it, because then now the parliament becomes my Legislative Assembly in terms of Article 357. Because under the President's Order 356, the parliament has the power to make laws for me. This is the whole constitutional manipulation. Now, not only that, they use 367 to get rid of 370, and then they kill 367 itself. Because in terms of the second notification, the whole of the constitution is applicable to me. Now, without any modification, without any exception. You use 367, you alter 370, you take it back, and then you kill 367 itself. This is the manipulation part of it. That's what we are agreed with. It's not a bona fide action. It's not a legitimate action. That is not the way you deal with the states. Whatever may have been the situation in the state, whether it's national security, whether it is anything else, those are the matters of law and order. What is the 370 to do with what happens on the streets of Srinagar or in Kashmir? It has nothing to do with it. May I tell your lordships, all the laws which were applicable to us prior to 2019 continue to be applicable to us. Whether it's Unlawful Activities Act, Prevention Detention Act, whether NIA Act, they continue to be. The difference is one. They say stone pelters have gone down, the militant activities have gone down. Those are the issues of law and order. I see no connection between that and 370. You got rid of 370 itself. It is not because of 370 those things were happening. There's no connection. Yes, you might have done development after that. That's a different issue altogether. Done or not done, I'm not here to comment on that. But 370 as a matter of fact, as a matter of law, that where a government wants to do something, but there is an obstacle, a constitutional obstacle. Therefore, the government wants to get rid of it. Just like in case of fundamental rights. Just in case of fundamental rights, if there's a fundamental right which doesn't allow the government to pursue a certain policy, then obviously the government has the power to amend that, saying that it cannot be done because we want to have a particular policy. 370 was altogether different. It gave us constitutional autonomy. But then the law and order situation is used as a matter of national security. And these two orders are passed.
Now, what next? Let's cross this bridge. Now we've got this point. The next point, what would that be?
What you want me to conclude immediately, I will.
No, Mr. Shah, please don't harbor that in the least.
We've
So
heard
many years in judging in a matter like this, I'll not do that unless you are satisfied that you are fully, not just that we should be satisfied that we have heard you, but you must also have that satisfaction.
I had so many things in this matter to say. You must have noticed, I have not read even a single document.
That's because of your mastery over the subject.
You asked me yesterday, what about instrument of accession? Of course, I could have read the document instrument of accession, but I told his lordship, please see clause 8.
I saw clause 7 also.
Read. I was reading the documents and then I would have taken 1 week. But since lordship is not going into those
Actually,
documents.
that's why I told you to conceptualize the last point, because now it brings clarity and focus. Those 7 points which you made.
Just look at it, everything is covered, nothing is left.
Otherwise, what happens, Mr. Shah, is that typically we make notes based on the dialogue which is taking place. There's always a danger that you lose some point which was made because the notes are made in the course of the dialogue. When you focus and formulate, then you're sure that you know.
I saw you also making the notes, but sometimes it is not like bullet points as they call it. This is without jurisdiction, because the job of an advocate here is, for example, there is no law on a point. I will have to persuade. Persuasion requires time by us. Persuasion can't be done. Sir, President has no jurisdiction. Okay, sit down. That is the end of the matter. I can't do that. How can
But
I
when
do
you-
that? I
but
got to explain who
Mr.
the
Shah,
president is.
After you've
What-
done the persuasion, you have to do the conceptualization.
Yes, yes. That's why I did that. First exercise I have done as a counsel. I have in my own understanding that what could be the ultimate issue, what could be the result of this litigation, where such a serious issues are involved and relating to a state, a federating state, how should this court respond? And not only, there is one more important thing for us. This is the last forum available to the people of the state that I would say that your lordship understands it. There is no one to take it back. As I see the political climate in the country, there's no one to take it back. It remains as it is. So therefore, all eyes are on this court, how this court will respond. And I, as a humble servant of this court, it's my duty to say what people think. The place from where I come, the people think about this 370, what has gone wrong, why are they hurt, why are they disappointed? Something will have to be said because this is a last resort. If assuming, I don't know what your lordship ultimately, when your lordship will retire to the chambers and dictate the decision, but ultimately what happens? Either it goes for all times to come, 370 as it is, or we get back what we lost on 4th.
Shah, we have to decide according to law or according to sentiments.
One more thing I wanted to say.
People are happy because of the development, because of the employment opportunities.
Nobody sells a country, sir. Whosoever may be in the government, this is our experience. Whosoever is the government, everybody tries to do his best. All government, nobody sells the country as such. Roads are made, maybe you make it a greater scale, somebody make it a smaller scale. Hospitals are built, education institutions, that all governments.
We need not go into all those because.
No, sorry, Sir General said so. So therefore, I'm just saying that's all the governments do, of course. Good things always happen.
We're addressing a constitutional argument, and we have to deal with it.
The last one which I would like to submit because as I see this is an important matter for us in that I remember only one thing, few things I need your lordship to know that. That is sometime back the great leader of this country, Mr. Atal Bihari Vajpayee, came to Srinagar and he delivered a speech. And he said that the issue of this Kashmir, I am going to solve within the purview of Jamhuriyat and Insaniyat. Unfortunately, the respondents killed both on 5th and 6th August. I would only pray when your lordship retire to the chambers and dictate the judgment in this case. Let the words of truth and justice trickle from your lordship's lips. That's what I would say. We are looking up to you. We have full confidence in this court, and we believe that the justice will be done to the people of the state of Jammu and Kashmir.
Thank you, Mr. Thank you very much, Mr.
If
Shah.
anything is left, I would.
Thank you, Mr. Shah. Thank you very much. Who will be
There
addressing?
were some judgments also which I wanted to cite for every submission which I made.
Can you, Mr. Shah, can you just do one thing? On the judgments, they will all be in the compilations which have been filed.
If anything is
You can
outside
maybe
that.
give us just 2 pages, a short,
Short.
just a sentence or two why you are relying on the judgment, just as Mr. Subramaniam did.
Now-
That will help us.
Now I understand. Sometimes it becomes too overwhelming for the judges also. Go on hearing a case all the time.
Not
same
really,
case.
I'll tell you what happens, Mr. Shah, is this, that at the end of it, when, the dust and the din of the court has settled down and you are left with yourself in a small office to dictate a judgment, as all of us do, conceptualization always helps, because that's when you really have to sit back, close everything, shut yourself to everything else but the core of the case. And that's why it helps, actually.
God bless you.
Thank you very much. You've done it admirably. Thank you
I
very
have
much.
these 2 things done. The constitutional autonomy as on 4th.
Yes, please give us that. Yes.
And number 2, also some few judgment, but I will indicate the paragraph only to support.
Absolutely.
What was the position earlier? What is the position now? I'm
Thank
grateful to you.
Thank you, Mr. Shah.
Thank you.
We'll now have Dr. Dhawan.
position, Mr. Shah. I don't understand the electronics, my lord. Therefore, I'll have to rely on my friends. Call me a Luddite if you want, but that's the position as it stands.
But I noticed Mr. Shah was also on his iPad. He was pretty up on his iPad.
I can learn during this process or not is another matter.
Dhawan, the Chief Justice made me do it on the last Constitution bench. That was my first endeavor, I must confess.
The practice of each court differs. Some we go with all our files, some we come, my lord, with PDFs. Don't even.
Now we are evolving towards this, really.
No, this is a far better system, my lord. It's the question of getting used to it.
Absolutely. Mr. Dhawan, actually, it's the ease with which we have been flipping through documents, volumes, it's only because we are electronic. Otherwise, can you imagine, 5 court masters handing over a new volume and us giving that back to them?
Actually, if there's a brief, then there is no problem. When the brief is many briefs in large volumes, then the utility of this is, I think, much greater, where the records are very voluminous.
And the giving of books, my lord, handing over, flagging them for your lordships to look at. But I'm hoping I'll be assisted, my lord, by my brilliant assistants. My lord, I think when we start with the Constitution of India, we have to recognize that India is the most diverse country in the world. If you take the whole of Europe, the whole of Americas and part of sub-Saharan Africa, you have a diversity. And that diversity is totally and completely unparalleled. And that diversity is reflected in this Constitution. And it is not just Article 370. There are many other articles also, which I will show to your lordship presently, where the legislature of the state's consent is required, or concurrence is required, or it has a condition precedent to put in. And it is this factor your lordship will bear in mind, which will have an impact on other cases. Take, for example, the Podial case. The Podial case concerned whether there should be a reservation for bhutias and lectures. Now, this was obviously totally contrary to the Constitution, which says that you cannot discriminate on grounds of religion. We got a split decision, but bearing in mind the fact of the history of Sikkim and the fact that the Nepalese were considerably in power, your lordships then took a pragmatic decision as well as a principled decision, which I'll show to your lordship presently, to say, no, despite that particular provision, we have to honor the historical promises made to the people of Sikkim. And this is something your lordship will bear in mind, because our Constitution is replete with promises to the people. I mean, take 3 and 4, my lord, to start with. This is the Achilles heel of the Constitution, that there is no territorial integrity. It is so peculiar to the Indian Constitution that we don't find a parallel as far as this is concerned in most of the constitutions of the world. Some joined the American Constitution with reservations like Texas, most didn't. So you have to bear in mind that 3-4 is such an important provision, and it is central to the argument that I'm going to advance before your lordships. And as Mr. Shah has pointed out, this had on the 4th of August a proviso. That is in CO 48. I can take your lordships through that because it's important to understand. This would be, my lord, in volume 3, PDF. PDF 13. I'm getting good at it, my lord.
You actually started using the language, you're saying PDF.
Right.
A PDF page?
No, no, it's much easier if one masters this. But I still believe in the quill pen, unfortunately, Malone. Because I find that whenever one has to write propositions, it is better to write them by hand rather than dictate them.
I would agree with you.
Much better.
Dr. Dhawan, there's one area where I still, despite my love for technology, I'm still conservative, which is when I read a book. When you actually read a book, you know, wrapping up at the end of the day, the joy of actually having paper in your hand is.
Well, that is going to finish, Malone. I have a huge library, very diverse, not just law. I wanted to give it to the Supreme Court, but there are no takers.
Who said that?
I said that to the Supreme Court Bar Association. This will have Marxism there, Eliot there, all kinds of novels there. If there are takers for it, the only takers at present offer I got was from Chanakya University in Bihar. Because that entire library is a collection of many things. Stuff on paintings, stuff on cinema. Now,
Dr. Dhawan, I mean, apart from this matter, please do walk across to the judge's library and have a word with our librarian, the registrar library, Ms. Uma Narayan. Please have a chat with her. I'll also speak to her.
I'll do that. Let them come and see the library, and whether the Supreme Court should have a purely legal library, my lord, or whether it should have a diverse library.
Oh, we have a diverse library. We pride ourselves on having books apart from law, actually.
That's right. And that's important, my lord. The question is always one of space, my lord. Nobody today has space. Most of my colleagues, my lord, Professor Galanta, Rick Abel, they all are sending messages, my lord, in Facebook. Does anybody want a library on law and society? It is available. Please let us know. We will pay the expenses for transport. There is no space, my lord. That is the real difficulty that is faced.
I think there's something that
all the opinions and submissions are there, my lord. The unpublished papers are there. There are books that I never published, my lord. But who will want interested in that? Certainly not my children, my lord.
But actually, Dr. Dhawan, you may be, with respect, you might be wrong for this reason, that if you digitize this collection, today there are resources across the world where they are putting this out into the commons. Yes. And the idea is by putting it out into the commons to allow researchers globally to access this. So there's a great deal of interest actually.
My university came to me and said that we'll have to tear apart all these black volumes of yours. And I said, well, let's leave it for the moment.
I think Mr. Venugopal has, through Mr.
Venugopal,
a digitized entire library, which is now available for public access. Antiquarian books. He collects antique. That is digitized and anyone can access it.
One of the finest libraries I've seen, of course, Mr. Ashok Sen had a brilliant library. Venu, of course, has a super library. There's a lawyer in Mumbai called Mr. Nadir Modi. I don't know if you ever have walked into his library. He has an amazing library in a place like Mumbai, in the heart of Fountain, you know, where space is such a constraint. But he would never lend his books because he says, you know, when lawyers take my books, they bend the book for photocopying it, and then the binding goes to seed.
We have this side now, beyond Court 5, going, that entire wing is totally vacant, free floor. Where during the COVID, the late Chief Justice Indra Malhotra wanted to donate her father's library. And at that time, we couldn't locate any place, so we went hunting, and that whole thing was vacant. But because of the COVID lockdown, that committee that I was part of couldn't get it, sort of access it. But if a new library could be made on this side, so if you'll also find out, the entire 3 floors are vacant because everything has moved across the road to the new administrative block.
As we know, we are now in the process of constructing a new building for the Supreme Court in this complex at the back.
They will all come as part of actually Justice plan to have additional building for the Supreme Court. So a lot of it will, is part of that planning will have to go. Maybe something more comes out of it. Space will be created. But you were mentioning with Dr. Aman, the Chanakya. I had an opportunity to go to Patna and see almost a very large percentage of new judicial recruits in Patna, and very, very eminent people.
Faizan Mustafa has just taken over.
They came from this university. And I was interacting with them as to how many of them, and very large, I think almost 40% women. And they were a lot of them were products of this university who had got into the judicial service.
Because when I spoke to Faizan, he said, I spent 17 crores in building the library of Nalsa. And I have to do it all over again, so I'm happy with your books. I said, come and see the library first.
Incidentally, Mr. Singh, you know, Mr. Sorabji's family gave us his personal collection, the Judges Library. And in our Judges Library, we have unveiled a new section called the Soli Sorabji Biblioteca. We have a very large oil canvas painting of Mr. Sorabji, and to commemorate him and his family when they were vacating the Niti Bagh house. Ms. Zina Sorabji called up and said, are there takers in the Supreme Court? So he said gladly. So our librarian went to his house. This was during the pandemic. She boxed all the books, brought them here, and then some Jindal Global Law School too.
What if I find any takers?
Good building in Kerala. We had a library in there, of course, most of it were reports. Now, my lord, the judges have, there is a proposal, my lord, to float a trust and then, my lord, put up a new building or in this refurbish the same old building with, and therefore we are actually looking out for books. Therefore, if Dr. Dhawan's library is available, therefore, my lord, unless the Supreme Court librarian is quick on the tape, we need actually tell him.
So many offers, Mr. Dhawan, in short time.
The CBA, my lord, a few years ago was, please take it. You don't need an oil painting of me. You don't need my name there. Just take it and make sure that the diversity is maintained. If somebody wants to book on Renoir, he should be able to access it from it.
Normally do it at 4 p.m. today.
So, Mr. Dhawan, you have offers from north as well as south. Patna and Cochin.
Right.
Iowa City.
So, but this has happened. I know a university in Tamil Nadu. I think the former Attorney General gave his full library. A lot of these universities which have been strengthened with libraries donated by councils. GR donated his entire library there. So it's
right.
It's certainly a place where lawyers can go and do some research. Should not become a samosa pakada place. As I said, short of that, yes. For true research, yes.
That's true. That's true.
That is the problem.
Now, this is the problem.
This is the problem.
This is the problem which I have. Incidentally, one second. The new building which we are constructing of the Supreme Court, the entire ground floor is going to be used for the library for the SCBA, library for SCORA, for the Women's Bar Association. That's the whole. My learned brother, Justice Suryakant, Justice Sanjeev Khanna, Justice Gawai, and Justice Kaul and I were invitee members because we are not on the building committees of our three colleagues. Now just wait for the new building which we are constructing. We are showing it to the SCBA.
As technology is going, nobody will have to go to a library to read actually. That's what is going to happen. It's happening already. So that access to information will not be a problem.
So now that's why we have conceived of a new project, right? Our project is coming up now. Yes, Doctor.
Anyway, I was taking the first, my lord, article that I want to show to your lordships to demonstrate the diversity, because it's not just limited to those special provisions from 371A onwards. In fact, for Nagaland and for Mizoram, they say you'll need the legislature of the state to act. I'll show that to your lordships before you interfere with any customs. Now here is an impediment. It's very different. I'll show that to your lordships. Now, my lord, come to 3 and 4, my lord, to begin.
Article 3.
I want to just show, my lord, volume 3, my lord, PDF 13. This was yes, I'm talking of the CO 48 that brings in the provision, my lord, into Article 3.
Oh, document 3.
Document 3, I'm sorry.
What page? PDF? 1-3. Yes, we got it. 1954 CO.
Now, my lord, straight away at the bottom of that page, you'll see in Article 3, they shall be added the following further proviso, namely, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. $368 कहाँ है कौन से पेज पे Mr. Shah was referring to.
We read the proviso with Mr. Shah.
You read the proviso, my lord. I also wanted to read the proviso, my lord, to 368. And then I'll be done with CO 48. That's page 411 at the top, my lord.
PDF page number?
18.
18.
PDF 18.
In volume 3?
Yes, same volume.
We're reading the proviso, Mr. Dr. Dhawan?
I'm going into the bottom of the page, my lord, on part 20, because these are relevant to us, my lord. If the only way out is an amendment, then these provisions are crucial both to Article 3 and 4, to 370, and a possible amendment, if any. I'll just read that, my lord, and I don't have to read the rest, because much of it has been read to your lordships. To Article 368, the following proviso shall be added. namely, provided further that no such amendment shall have effect in relation to the state of Jammu and Kashmir unless applied by the order of the President under clause 1 of Article 370.
So once there's an amendment to the Indian Constitution, that for the purpose of Article 370 is placed on the same footing as any other provision, so that you have to have a specific amendment.
That's right.
By an order, presidential order under Article 371.
It's a two-stage process. The first is you must have an order of the President under clause 1. Before that, you can't proceed with the amendment.
So clause D of, subclause D of clause 1 is then made operational. You have to have a presidential order under D.
That's right. That's right. Well, I'll come to those points a little later, because whether 370 could be amended at all or 3 and 4 could be invoked during President's rule is a major point that we wish to make at some point in time. Because all the provisions there relate to governments assisted by councils of ministers. As far as Article 3 and 4 is concerned, you have to circulate the bill to the legislature concerned. There is only one judgment of the Delhi High Court which goes the other way, but your lordships have insisted that this is a mandatory condition. This has not been done as far as the invocation of 3 and 4 is concerned. So let me take my lord to 3 and 4.
Here, page 367.
State separating of territory.
Dr. Dhawan, which page are you on? I missed out.
I'm on the Constitution.
Article 3 and 4.
I'm sorry, my lord, I should be more prepared in cross-referencing.
I was probably reading something with.
No. I'll come to my written submission in a moment, my lord. There is something elaborate on 3-4. Once again, I've quoted from the judgments rather than actually refer to them. I'll give your lordship the PDF numbers. Now, my lord, Parliament may by law form a new state by separation of a territory from any state, or by uniting 2 or more states or parts of states, or by uniting any territory to a part of the state. Increase the area of a state, diminish the area of a state, alter the boundaries of the state, alter the name of the state. Now, my lords, the proviso here, it was brought in, my lord, by the 5th Amendment, as your lordship will see at the bottom of the page, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, unless where a proposal contained in the bill affects the areas, boundaries, or name of any state, the bill has been referred by the President to the legislature of the state, expressing its views thereon within such period as may be specified in the reference, within such further period as the President may allow. This, in my respectful submission, is a mandatory provision. The case law, my lord, suggests all you have to do is refer the bill. You don't have to refer future amendments to the bill. But this is a mandatory provision. And it will affect, my lord, the JK Reorganization Act of 2019. Because that is invoked, my lord, under Article 3 and 4. Territories are changed, names are changed, etc. The 2 explanations I'll omit for the moment, my lord. They were brought in after Berubari, my lord, because there was some concern as to whether you can take parts of territories and deal with them separately or not. And therefore, you have explanation 1. In this article, state includes a union territory, but the proviso state does not include a union territory. Now, Mr. Sibal was at pains to apply this particular explanation to the clause 1, my lord. He said there were many combinations. Actually, this did not, explanation 1 and 2 were not applicable to the state of Jammu and Kashmir. Then comes the consequential provision 4. Any law referred to in Article 2 or Article 3, Article 2 is relevant for Sikkim.
It contains such provision.
Because it joins subject to some conditions which are there in Article 371, in the 371 series, shall contain such provisions for the amendment of the first schedule and fourth schedule as may be necessary to give effect to the provision of the law, and may also, so first, my lord, is the amendment of the first and fourth schedule, and may also contain such supplemental, incidental, and consequential provisions, including provisions as to the representation in Parliament and in the legislature or legislatures of the state or states affected by such laws the law Parliament may deem necessary. Now, these supplementary provisions are what is contained in the JK Reorganization Act. The argument made is you have representative democracy in the Union Territory, you may not have it in Ladakh. But nevertheless, the entire statute is really made under Article 4. Now, my lords, if I may show some other provisions to your lordships on diversity, my lord. This I will explore later when I show your lordships the decisions on Article 3 and 4. Very strange provision, my lord, in Article 164. Well, the special provisions, my lord, on SC/ST, your lordships will see, there is an entire separate chapter on it. And our affirmative action is very different from that of any affirmative action in the world. So 164, my lord. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in charge of tribal welfare who may, in addition, be in charge of the welfare of scheduled castes and backward classes. Now, this came in, my lord, by way of a small alteration for Odisha. The name was changed. But this is an important provision which once again shows the diversity, my lord, that exists. Then, my lord, your lordships will come to Article 244, my lord. Sorry, my lord, before that, my lord, the Union Territories, if I may just indicate that to your lordships, that's part 7.
239, right? 239.
Now, my lord, all the amendments by and large to creating Union Territories, except for Chandigarh, my lord, have been made by constitutional amendments. Here we see the creation of a territory, my lord, under Article 3 and 4. So let us have a look, my lord, save as otherwise administration of Union Territories. This was put in by the 7th Amendment. On Article 3 and 4, Mr. Chandra Uday Singh, my lord, will take your lordships through the State Reorganization Committee report. I didn't go into that, my lord. because he is going to develop that argument. Every union territory shall be administered by the president, acting to such extent as he thinks through an administrator to be appointed by him when with such designation as he may specify. Notwithstanding anything contained in Part 6, the president may appoint the governor of a state as the administrator of an adjoining territory, or where the governor is so appointed, he shall exercise his functions as such administrator independently of the Council of Ministers. So, my lord, as soon as you become a union territory and subclause 2 applies, the president may appoint a governor of a state, he may appoint somebody else, but at the end of it, it says he shall exercise his functions independent of the Council of Ministers. Now, this, of course, has changed, my lord, in the context of Delhi, etc., but I'll come to that in a little. Then, my lord, your lordships will see 239A. Parliament may by law create for the Union Territory of Puducherry a body which is whether elected or partly nominated or partly elected to function as a legislature for the Union Territory or a Council of Ministers, or both with such constitutions, powers and functions in each case as may be specified. Puducherry, my lord, came from a constitutional amendment. Parliament was authorized, my lord, to make a statute, and it did so. The next, my lord, is a provision your lordship is very familiar with, 239AA. That is Delhi, and it contains, my lord, in the amendment itself, not through a circuitous route, my lord, of 3 and 4, but in the amendment itself, it contains the provisions for a legislative assembly, the division of powers, my lord, then, my lord, failure of constitutional machinery, and then finally 240, my lord. The president may make regulations for the peace, progress, and good government of the Union Territory of Andaman and Nicobar, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu. To this we can now add, my lord, Ladakh, as a consequence, my lord, of the changes that have been made. But of course, it's not amended, my lord. It's done as a consequence of Article 3 and 4. And therefore, the president completely takes over. There is no parliamentary government at all, no reference to the people, and there is a lieutenant governor or a governor in charge. And that is the fate of many union territories, my lord, unless provisions are made. When you convert a state into a union territory, and there is some doubt as to whether you can, because without explanation 1, it is clear we are talking about states. And this would be the only occasion in the history of India where a state has been reduced to a union territory. It is, and now when we talk of transformative constitutionalism, it is important to bear in mind what this really means. As far as Ladakh is concerned, a provision similar to 240 will apply, which is there, of course, in the Reorganization Act. And as far as Jammu and Kashmir is concerned, it becomes a union territory with the limitations that are there in the JK Reorganization Act. This is unprecedented, Manoj. If, for example, you wanted to make a union territory of Delhi, there were special reasons, you passed an amendment to the Constitution. But here, by a circuitous procedure, you have converted through Article 3 and 4 2 union territories from a state, one with some representative government, one with none. Then, my lord, if I may take your lordships to 244. I'm just, my lord, on the question of diversity of our constitution. which makes it very different from others and more exciting than others.
We'll continue on Wednesday.
Your Lordship,
The 16th, right?
Wednesday.
There's a small housekeeping matter. There are additional volumes of case law and documents Mr. Dushyant Dave's team have given. In fact, it appears that they had given, because there was a Google form, it might have been missed out by them. So request that also be taken on record. There are about 3 cases.
But were they given in advance with the other volumes?
Yes. We had
the notary council.
We don't seem to have the record, but it appears that they had given of the other volumes. Case law. It was case law and documents. One.
Is there any overlap with the case law and documents already on the record?
Done the deduplication. There is no overlap.
There's no duplication. All right.
And there is also a chart of intervention application, the essence of intervention.
All right. That we'd like to have, so that we'll glance. We'll have
also
the.
obliged.